right, and now, Deb, I'm making you the host. And you are good to go, Senator.
Thank you, Alan. Good afternoon, everyone, and welcome to the Zoom meeting for the Executive Departments and Administration Committee. We are going to be hearing 3 omnibus bills this afternoon, but before we get started, I'm going to ask the committee if we could have a moment of silence to address the recent death of Mr. Floyd, and maybe we can send our condolences to the family for their loss. So if we could have a moment of silence. Thank you all. So I'd like to welcome everybody. I am Senator Sharon Carson, and I am the chair of the Senate Executive Committee and Departments. Today, we're going to be hearing House Bill 1245, House Bill 1491, and House Bill 1234 FNA. Additionally, we will be hearing amendments 1382S, 1385S, and 1371, respectively. Before we get started, I'll read through a checklist to ensure that the meeting that we are holding is in compliance with the Right to Know law. As the chair of the Executive Departments and Administration Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and to listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I am confirming that we are providing public access to the meeting by telephone, with additional access possible by video and other electronic means. We are utilizing Zoom for this electronic meeting. All members of the committee and selected legislative staff have the ability to communicate contemporaneously with this meeting throughout this platform. And the public has access to contemporaneously watch and to listen to the meeting on Zoom, YouTube, and via phone by following the directions and the links provided on the General Court website. We have provided public notice of the necessary information for accessing the meeting in the Senate calendar. We are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remote-senate@leg.state.nh.us or call 603-271-3043. In the event the public is unable to access the meeting, it will be adjourned and rescheduled. Please note that all votes taken by this meeting shall be done by roll call vote. We're going to start the meeting by taking a roll call attendance. When each member states their presence, please also state where they are and if anyone else is in the room with you during this meeting, which is required under the Right to Know law. I will call the roll. Let's see, Senator Kavanaugh.
Hello, Kevin Kavanaugh, my home in Manchester. My son is in and out, but he'll be leaving. Besides that, I'm home alone.
Senator Rosenwald.
Hi, Cindy Rosenwald. I'm in my dining room. My husband might walk through here, but he won't probably be staying.
Senator Chandley.
Good afternoon. This is Shannon Chandley. I'm at home in Amherst and I'm alone in the room.
Senator Reagan.
Senator Reagan's home, alone in Deerfield.
Okay, and I am Senator Sharon Carson. I am at my home in the kitchen in Londonderry. Okay, a couple of other things. I just want to introduce some of the other people that you might be seeing. We have Mr. Cameron Lapine. He is the committee secretary, and he is going to be taking the records of this executive session and notes during the public hearings and generating the hearing report. We have Ms. Deb Martone. She monitors hand raising, informs me who has questions. She also monitors and manages attendees wishing to speak during the public hearings. We have Mr. Griffin Roberge. He is an he assists the host. And finally, we
Senator,
have,
you had muted yourself for a second. You're good now, though.
oh, okay. And finally, we have Monica Cooper. She monitors any technical problems. She works with the policy staff to contact any missing committee members. She also communicates with the host to inform me of any problems with any connectivity, and is in contact with GCTS to resolve any issues. So I think with that, we can go ahead and get started. We're going to open the public hearing on House Bill 1245. Is Representative Ebel available to introduce the bill?
Yes, I'm here.
Okay, why don't you go ahead and get started?
Okay, for the record, my name is Karen Ebel. I represent Merrimack District 5, which is New London and Newbury. And I'm here to introduce HB 1245. HB 1245 would create a legislative committee to review or to continue the work that's already been started by a committee that I chaired that was established under HB 4 to review all non-regulatory boards, commissions, councils, advisory committees, and task forces, and to recommend the repeal or perhaps the reduction of legislative membership in those committees, statutory committees and commissions. As many of you, or as you know, I'm sure we have a great deal of non-regulatory committees and commissions. And last summer, I worked diligently, or I should say the House Committee Services folks worked diligently to really do a compendium of all these commissions, and they came up with, I think, about 225. And as you know, many of us serve on many of these, and the appointments are really a heavy lift, both for the Senate President and for the Speaker. And there's a sense that there are quite a few of these that aren't meeting with any regularity, if at all. So as part of the trailer bill, HB 4, actually there was a committee on committees that was created, and I chaired that committee, and we started our work in the middle of November, but our report was due in February of 2020, and there was no way that we could get through all of these committees and commissions. And so this bill would continue the work that was done. I had introduced the bill before the work was done by the other committee on committees. And so what you'll also see in this bill is the recommendations of the HB 4 committee as to what should be repealed or the legislative membership reduced. I should add that as far as our methodology is concerned, we worked very closely with the administrative agencies that were responsible or a part of the commissions to talk to them about how frequently the folks met, whether they thought the commissions should continue. And we also had executive orders that we were reviewing, and we had the governor's staff, Jonathan Melanson, with us, and also the labor commissioner, Mr. Merriman, with us. And anyway, we worked with all of them, and we did I think, a very comprehensive job in reviewing the commissions. And so what you'll see in here is a bill that creates a study committee to continue what I think is that very important work, and to also make recommendations on the repeal of, I think, 20-something committees and commissions. I guess the only other thing I would say is that there was work similar to this done in 2010, and it seems like these proliferate like crazy. And every once in a while, we have to dig deep and see whether they're still performing the service that they had been created to perform. And I'd be happy to take any questions.
Thank you very much for your testimony. Do we have any folks who have any questions? Any committee members? Okay. Okay, do we, just as a question for our admin, do we open it up for the public to ask questions at this point?
Go ahead.
I was just going to say that you can go through the speakers who have signed up at this point.
Okay, but I think we need to differentiate whether or not they are speaking on the bill or on the amendment, because we haven't
Yes,
introduced the
absolutely.
amendment. Okay, okay.
Okay, Senator. The next speaker is Elsa Rogers.
Good afternoon, Ms. Rogers, and thank you for attending the meeting.
Hold on, I'm trying to let her go.
Okay,
Okay,
Hi, I believe that I might have made a mistake with signing up for it because I want to speak specifically towards the part that is for tobacco 21.
okay,
okay.
thank you. Next, we have Bob Quinn. And let me get him. Mr. Quinn? Mr. Quinn?
I don't think I signed up for this.
Okay. All right. You're safe. And I believe, Senator Carson, that may be all the speakers we have on this bill, on the bill itself.
Okay, thank you very much, Ms. Martone. What we need to do now is we need to introduce the amendment. But before I do that, as I said, this is an omnibus bill, and there are a number of bills that have been rolled into this. And what I'd like to do is read by title and name the number of bills that have been rolled into this amendment before I have Senator Rosenwald introduce it. First is Senate Bill 437, relative to incarceration under a suspended sentence. Senate Bill 589, allowing seasonal docks on certain lots in the town of Freedom. We have House Bill 1245, which was just introduced to us. We have House Bill 1230, relative to credit for reinsurance. Senate Bill 704, relative to technical change to certain appeals. Senate Bill 441, relative to the definition of secured premises for the purpose of criminal trespass. House Bill 1375, relative to cancellation of commercial insurance policies. Senate Bill 430, relative to the Child Fatality Review Committee. Senate Bill 434, relative to the purchasing authority of the Department of Administrative Services. Senate Bill 445, relative to the residency of children of members of the armed forces. Senate Bill 452, making certain technical changes to the insurance laws. Senate Bill 462, relative to state energy management. Senate Bill 472, relative to funds for the Division of Veteran Services. Senate Bill 517, relative to the public information and permitting functions of the Office of the Commissioner in the Department of Environmental Services. Senate Bill 539, relative to classification of certain employee positions. Senate Bill 544, relative to the filing of administrative rules of state agencies. Senate Bill 595, relative to certain unclassified positions in the Department of Health and Human Services. Senate Bill 627, establishing a dock registration procedure. Senate Bill 628, relative to the authority of the Department of Environmental Services for emergency action at hazardous dams. Senate Bill 632, relative to enforcement of the state building code by municipalities and the state fire marshal. Senate Bill 636, authorizing the Commissioner of Safety to appoint security officers at department facilities. Senate Bill 729, relative to the Board of Medical Imaging and Radiation Therapy. Senate Bill 738, relative to suspension or revocation of motor carrier privileges for default non-compliance or non-payment of fine. Senate Bill 740 relative to the definition of healthcare facility under the State Board of Fire Control. Senate Bill 752 relative to the authority of the Department of Administrative Services, Division of Personnel. Senate Bill 471 relative to funds for the Division of Veteran Services. House Bill 501 using fees from the registration of commercial animal food sellers to fund the cost of care program in the Department of Agriculture, Markets and Food, and establishing a commission to study the identification of unregistered animal feed products being sold remotely in New Hampshire. Senate Bill 668, establishing an offshore wind commission, establishing an Office of Offshore Wind Industry Development in the Department of Business and Economic Affairs, and making an appropriation therefore. Senate Bill 248, increasing the age for sale and possession of tobacco products. Senate Bill 418, relative to workers' compensation audible policies. Senate Bill 672, relative to behavioral health services for children and certain revisions to notification of discharge for individuals found incompetent to stand trial and non-emergency involuntary admissions, revocation of conditional discharge. Senate Bill 706, relative to appeals under the New Hampshire Child Protection Act. Senate Bill 621, relative to specialty beverages. Senate Bill 633, relative to recovering housing. Senate Bill 1252, relative to large groundwater withdrawals from replacement wells. And finally, House Bill 647, relative to Lucky 7 tickets. So there were a lot of bills that were rolled into this one bill. And I would like to thank Senator Rosenwald for working on the amendment. And so Senator Rosenwald, I'm going to turn it over to you to introduce the amendment.
Thank
Excuse
you
me.
very much, Madam Chair. And I need to give a shout out to Deb Martone and also to Sarah Pershino on this, because they really helped with the proofreading of this epic.
Sorry, Senator Rosenwald. Senator Carson, you have to close the hearing on the bill itself because this is a non-germane amendment, and then open it as a separate hearing.
Okay, so we'll go ahead and do that. We'll go ahead and close the public hearing on House Bill 1245. And we will go ahead and open the public hearing on Amendment 2020-1392S. And we will recognize Senator Rosenwald.
Thank you very much, Madam Chair. I'm pleased to introduce this amendment, which, as you said, is an omnibus. It adds a variety of agency-related bills to the underlying House Bill 1245. I realize that an amendment of this size and scope is unusual, but then we find ourselves in an unusual time in which circumstances dictate a creative legislative approach. 1392S is a cleanup amendment to the 1382S, which was published in the calendar. It simply corrects language that the House had amendments to on tobacco age, which is section 110 through 123, and has Senate language on the Offshore Wind Commission members. I do want to mention that the Department of Health and Human Services would like to offer slightly different language about tobacco age and raw milk. I'm assuming that they have signed up and they will speak to that, but with that, Madam Chair, I'll stop and allow them and others to speak. Thank you very much, and I will mute myself.
Thank you very much, Senator. Ms. Martone, I'm going to, we'll get started in here. Are there any questions from the committee? Okay, seeing none, why don't we go ahead and open it up to the public?
Thank you, Madam. Thank you, Madam Chair. The first speaker I have is Cy Chirella.
Good afternoon, Mr. Chirella.
This is Dr. Sai Chirala. For the record, my name is Dr. Sai Chirala. I'm the Bureau Chief for the Population Health and Community Services. and I'm here to speak for two areas. One is for the child fatality language. It's Amendment 202-1392. It's on
Mhm.
page 18, line 7 and 8.
Okay, please proceed.
Thank you. Thank you so much. We thank Senator Carson for providing, supporting this language, for putting this bill for us. This is specifically, we introduced this language to amend, repeal the language around, can you hear me?
Yes.
Okay, thank you. The language was, we requested this language specifically to repeal the requirements from the non-public session under RSA 91-A3. We have added additional language, and we have submitted the amendment to Senator Carson and Mr. Cameron Lappin. And the additional language that we wanted to request on the child fatality is, we wanted to add additional member from Fire Marshal's office and clarify the language why we want to complete the child fatality around improving the quality and comprehensiveness of child fatality data and integrating information from other sources of information. And the other piece that we wanted to include in this one is that the chairpersons of the child fatality would have a capacity to introduce invite any experts or other members of the public to the committee meetings as required.
Okay. Okay, thank you very much for your testimony.
I have
We didn't get that. Something happened and it was kind of cut off.
Who was that?
That was Dr. Sai Charella.
Charella.
Yep.
Yeah, we didn't get her last comment. There's the comment about they'd like to change for adding additional member from the fire marshal's office. And then they would like the ability to invite, for the chair to invite anyone to come in and speak to the commission, but it just kind of cut off at that point. So I don't know if she finished what she had to say or what happened.
She's still there, it
Back
appears.
on.
Yeah.
Okay.
Her hand's raised.
Okay, Dr. Charella, we didn't get the last part of what you said. Could you please repeat it?
Can you hear me?
Yes.
Okay, thank you. I think we are having some technical difficulties today. Sorry about that. The three things that I wanted to bring to your notice around the child fatality is, one is the repealing the language around the RSA 91-A3. The other three things that we wanted to include this was, one is around specific information around how to improve the quality and the comprehensiveness of child fatality data from other sources of data. The second piece is adding a representative from Fire Marshal's office, appointed by Fire Marshal. And the last piece is the chairpersons will have the capacity to invite any experts or a member of public to the committee meetings.
Okay, thank you.
Talk about can I follow up on the tobacco 21 or the SB 248?
Okay.
SB 248, this is page 50, line 4 and 5. We do want to include, we are appreciative of all the language that went into. The things that we just want to include in this, we would like to request the following language change on page 50, line 4. We want to add languages add the words "or derived from," which would include the FDA definition of tobacco product. So that means that the tobacco product means any product containing or derived from tobacco. That's the just two lines that we want to, 3 words that we want to add.
Okay. Okay, thank you very much for your testimony. Are there any questions from the committee?
Yes, I have a question, Madam Chair.
Yes, Senator Rosenwald.
I'm sorry, I couldn't find the raise hand function. Have we seen that child fatality language? It doesn't, the way Dr. Trala described it, it didn't sound like what Cam had sent out yesterday.
We did send the language, we did send the additional amendments language. Additional amendment. I'm happy to share, I'm happy to send the information again to Mr. Cameron.
Okay, please do that and we'll make sure that everyone gets a copy of it.
Sure.
Thank you, Madam Chair.
Okay. Are there any further questions from the committee? Seeing none, thank you very much for your testimony this afternoon. Okay, Deb, are we ready for the next person?
We are. That would be Rebecca Ross.
Okay. Good afternoon, Ms. Ross.
Good afternoon, Chairman Carson, members of the committee. Thank you for the opportunity to provide testimony today. I am General Counsel for the Division for Children, Youth, and Families, and we're here to specifically talk about sections 40 and 130 that incorporate Senate Bill 704, which is a technical cleanup of the TPR statute that removes an obsolete reference to the prior probate court statutes, as well as Senate Bill 706, eliminates the de novo appeals in abuse and neglect cases and allows parties to proceed directly to the Supreme Court in an effort to increase the timeliness of permanency in abuse and neglect cases. I'm happy to take any questions.
Okay. Do the committee members have any questions on those particular sections of the amendment? Okay. Seeing none. Thank you very much.
Senator, I have Melissa St. Cyr.
Okay. Good afternoon, Ms. St. Cyr.
Good afternoon, members of the committee. For the record, my name is Melissa St. Cyr. I am the Chief Legal Officer for the Department of Health and Human Services. And I just wanted to reiterate SB 430, the Child Fatality Review Committee. It's really important that the language pass that, because right now it doesn't allow us to have a public session. It exempts us from the ability to have a public session, basically meaning that we don't have the ability to go and do, basically open the committee up to others to participate in. So we want to make sure that that moves forward. That's really important. The other important bill is SB 740. That's relative to the definition of healthcare facility. Right now, the State Board of Fire Marshal comes in and inspects facilities, healthcare facilities for compliance with the fire code. And we want to make sure that we align what a healthcare facility is with what is defined as a healthcare facility under our licensing statute, so that they will be inspecting the same facilities that we license as a department. So it's just aligning those two statutes together.
Okay. Thank you very
I'm
much
sorry.
for your testimony. Are there any questions from the committee? Seeing none, thank you very much for your testimony.
I have Jennifer O'Higgins.
Good afternoon, Ms. O'Higgins.
Hi there, how are you? So my name is Jennifer O'Higgins. I'm the Legislative Liaison and Senior Policy Analyst for Behavioral Health at Department of Health and Human Services. I'm here to speak specifically to Senate Bill 633 relative to recovery housing. I want to thank the bill sponsors for bringing this forward. The housing is a critical concern throughout the state of New Hampshire, and this is DHHS requested legislation. A voluntary registry was established in 2018 through HB 1775. And this bill 633, as introduced, is seeking to correct an existing challenge with the state registry. There's three main pieces to the bill. One is a language change from alcohol and drug-free housing, changing that to recovery housing to reflect current terminology. A second portion to add additional safety documentation for houses to get onto the registry. Third and critical component to allow DHHS to prohibit or remove houses due to the severity or frequency of complaints. Then additionally, we did submit some language to Cameron and Senator Carson around after some conversations and public hearing on this bill initially, in working with Senators Carson and Kavanaugh, the amendment that the newest language that we put forward today would strengthen the original bill to address concerns that were raised in that initial hearing. The amendment goes further to require that houses on the registry be certified, and certification is based on the National Association of Recovery Residences standards. We already have in New Hampshire an existing National Association of Recovery Residents affiliate that acts as the certifying body and is currently certifying houses across the state. These standards would assist residents and communities to certify full and quality recovery housing residences. One additional component to this new amendment is also the addition of Section 4, which establishes a committee to continue to work with communities and recovery housing operators to adhere to national quality standards and to make recommendations for future policy change. So without this department requested legislation, we would continue to be held to the law passed in HB 1775, which requires the registry, but we have no authority as DHHS to remove those bad actors from the registry and don't have oversight or safety documentation requirements. Thank you very much. I'm happy to take questions.
Okay, thank you very much for your testimony. Are there any questions? Senator Kavanaugh.
Thank you, Madam Chair. Jennifer, thanks for doing that work. I just wanted to be clear too. I know the last time we met was, it seems like a lifetime ago in March, right before this emergency was called. But it's a good step, but I just want to be clear. I do want to look at this, really strengthen what we can in the laws that we have in New Hampshire to strengthen, to stand up to these, some of these houses that are really dropping in with 25 people in residential neighborhoods. So it's a start, and let's keep on working together. So thank you.
Thank you very much.
Are there any further questions from the committee? Seeing none, thank you very much for your testimony, Ms. O'Higgins.
Madam Chair, John Williams has a question. I believe his hand is raised.
Okay. Good afternoon, Mr. Williams.
Senator Carson, good afternoon, and committee members, and thank you for the opportunity and the tremendous work that you and your committee have done on the Amendment 1392S. We are very pleased to be here in support of the initiatives, and we pretty much have covered everything in the prior testimony that you heard from the other speakers. For clarification on the amendment that was being sought around the Child Fatality Review Committee, it's amendment number 0876S. And I think, Senator Rosenwald, if you refer to that, you'll see exactly what it was that the department is seeking to have inserted into the bill. It's very straightforward. Also, in regards to the testimony that Ms. O'Higgins just provided, we really thank the committee and Senators Carson and also Senator Kavanaugh for the tremendous work they've done in the area of recovery housing. The other items that are in there from the department, we appreciate your support and just wanted to round up our testimony with these comments. Thank you.
Okay, thank you very much, Mr. Williams. Are there any questions from the committee? Senator Rosenwald.
Thank you, Madam Chair. Mr. Williams, I'm looking at that amendment, and I think Dr. Chiarella said it changed the membership of the committee, but I'm not seeing that in there.
If I'm unmuted, if you go to page 1, line 2 of the amendment, you'll see that it adds by inserting after a following new paragraph, and you'll see the membership of representative from the fire marshal's office is appointed by the fire marshal.
Oh, okay, on line 9. Okay, but then it also changes the bold stuff in section number 1.
Yes, and I would defer to Dr. Chiarella on that specific language. It was developed in working in consultation with the Child Fatality Review Committee, and it was a very important change that we'd worked on. So I would defer to Dr. Chiarella for further comment on the language in the first section of the amendment.
Okay. Thank you, Mr. Williams. I do have a question because I have an amendment to Senate Bill 430 in front of me that's dated February 25th, 2020, and it's number 0876S. And I believe that amendment has the language that we were talking about with Dr. Trella, because the first section says improve quality and comprehensiveness of child fatality data by enhancing and integrating information obtained from autopsies, death scene investigations, death certificates, police reports, medical records, and other relative sources. The second section adds in the fire marshal's office. The third section gives the chairperson may invite any expert or member of the public to committee meetings. And then it repeals the section relative to the exemption of the Child Fatality Review Committee from the requirements for non-public session under 91A :3. Is there anything else beyond that you're looking for?
No. Senator Carson, you completely, perfectly stated exactly the amendment and the language that the department was looking to have included in this omnibus 1397S as a committee amendment.
Okay, because I thought we had already adopted this language. So we'll figure it out. Don't worry about it. We'll make sure that language gets in there if it's not there. While I have
Absolutely.
you here, I have
Yep.
a
And Senator
question
Carson,
I have a question for you, Mr. Williams, on Senate Bill 633, which is the recovery housing. I've got a draft amendment that's dated March 12th, 2020. Did that come from your folks?
that is correct. That is the final document that we had prepared in
Okay.
preparation for what would have been the executive session for the following week, but due to the COVID-19 suspension of the legislature, we never reached the point to having it sent to OLS, working with you and the members of your committee. So that's where we had left off in our conversation. So that is the working draft. And I do have an answer briefly on the amendment to the Child Fatality Review that the Senate passed the bill for the Child Fatality Review as reflected in the current amendment that you have before you. In other words, the 91A issue being addressed. We were planning to address and add, when the bill crossed over to the House, which hearing never took place, this additional language. And you were kind enough in readiness for that to work with us, work with the committee to actually develop the language that we're now seeking to have added as a committee amendment, which is the 087. I'm going to make sure I have the number correct here. The 0876S amendment. So I hope that explains where we left off on these.
No, thank you for refreshing my memory. That was back in February, so it's been a little while. But I think we can take care of that. Okay.
Thank you.
Madam Chair.
Yes.
Could I ask a question of you
Sure.
about the this child fatality review amendment from February is in your name?
Yes,
But
it is.
it doesn't appear that we took action on it in February, and I didn't have access to the hearing report. So I'm just, did we consider this language before and then not adopt it, or?
I don't believe so, Senator. As Mr. Williams said, we did adopt a part of it, but I believe it was, I guess you would call it a work in progress. So when it was going to go over to the House, I had this amendment prepared to bring to the House to the public hearing to add the other language. So that's why it's this way. So,
okay.
but
Thank
no,
you. That's really
no one ever
helpful.
saw it because we never had the House never had a public hearing.
That's really helpful. Thank you.
Okay, terrific. Okay, are there any further questions for Mr. Williams? Okay, seeing none, thank you, Mr. Williams. And Senator Kavanaugh, did you get a copy of the draft amendment from DHHS on this bill? Do you have it?
I'll have to look through my emails.
Okay, I will have Mr. Lapine send you a copy So that way you can take a look at it and you and I can talk about it.
Great, okay, thank you.
Okay, terrific. Thank you. Ms. Martone, is there anyone else?
Yes, but before we continue, Madam Chair, Dr. Chirella has her hand up again.
Okay,
No.
Dr. Chirella, could you briefly explain what you have to say?
I raised this is Dr. Sai Chirala. I just raised my hand to explain the process of the child fatality. I think Mr. Williams has explained it better than me. Thank you.
Thank you very much.
Very good.
Okay.
The next speaker is Doug Bartlett.
Okay, good afternoon, Mr. Bartlett.
Can you hear me?
Yes, we can.
Thank you. My name is Doug Bartlett. I'm the Director of Financial Regulations for the Insurance Department. And the purpose of this bill is to adopt the amendments to the NAIC, the National Association of Insurance Commissioners, model law regarding credit for reinsurance. These provisions are intended to implement the reinsurance collateral provisions of a covered agreement that were entered into between the United States Department of the Treasury and the European Commission, also known as the European Union, and the United Kingdom. This covered agreement creates a new type of reinsurer from a, quote, reciprocal jurisdiction, unquote, which is the European Union and the United Kingdom. Now, currently, reinsurers from foreign countries must post 100% collateral for any business they write in the US. There's a process that is currently in New Hampshire law for this reduction of collateral, where you go through the NAIC. What this does is it sets up an amendment to these new types of companies. So first of all, a reciprocal jurisdiction is a non-US jurisdiction subject to enforcement under the covered agreement with the United States. The covered agreement is an agreement entered into pursuant to the Dodd-Frank Act, is currently in effect and addresses in circumstances the elimination of collateral for entering into any reinsurance agreement with a ceding insurer domiciled in New Hampshire. That New Hampshire insurance insurer can reinsure business in that reciprocal jurisdiction under the same terms. And that's what's meant by reciprocal. Whatever they can do here, we can do there as far as collateral. And there's some other rules, but the big one is collateral. And I'd just like to consider, first of all, this is an accreditation standard. For those of you who aren't familiar with accreditation, the National Association of Insurance Commissioners has 23 what they call model laws that all states have to adopt so that there's no difference in the regulation for certain aspects of the laws between the states. And also would like to consider to pass this to avoid federal presumption. The states have to complete the necessary steps to amend the state laws to comply with this provision of the covered agreement within the 5 years of the signing of the covered agreement with the EU, or face potential preemption by the Federal Insurance Office, and that's a part of the U.S. Treasury. And this agreement was signed on September 22nd, 2017. NAIC reinsurance task force, of which we are a member. New Hampshire is a member. I sit on it. Met many times. We had public hearings. We had a very large 2-day public hearing in New York City on February 20th, 2018, and just numerous exposures and drafts at the NAIC, and all states got to participate, and the public also participate. And it was finally the adopted revised model law was finally adopted on May 15th, 2019. And with that, if you have any questions, I'd be happy to answer them.
Thank you very much for your testimony, Mr. Bartlett. Are there any questions from the committee? Okay, seeing none, thank you again.
Thank you.
Madam Chair, may I remind speakers that there is a 3-minute
Yes, of course.
provision when they speak?
Yep, that's fine.
Okay. The next speaker, Christian Citarella.
Good afternoon, Mr. Citarella.
Hold on. There you go.
Good afternoon, Mr. Citarella.
Thank you. My name is Christian Citarella. I'm the Chief Property and Casualty Actuary at the New Hampshire Insurance Department. I'm here today to essentially answer questions that you might have regarding the part of the amendment that was Senate Bill 418 relative to auditable workers' comp policies and added language to clarify penalties for noncompliance. Senator Kavanaugh was kind enough to sponsor this bill for the department. And I can answer questions if there are. If you'd like me to run through it real quick, I can do that as well.
No, I don't think we need to do that. So thank you for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
Madam Chair, we have Senator Waters.
Okay. Senator Waters, good afternoon. Did he decide not to speak?
He should be fine to speak.
It shows that he's still muted.
Okay. Senator Waters, are you there?
Yes, I'm sorry, I can't see you, but I hope you can see me.
Good afternoon, Senator Waters.
Thank you, Madam Chair, members of the committee, and thanks to all of you and to the staff for this extraordinary work to bring this amendment together. I'd like to speak very briefly on the two sections that were Senate Bill 668, which was offshore wind, and Senate Bill 248 on tobacco 21. The senators will be well familiar with the bipartisan legislation to set up an offshore wind commission. We viewed it twice in energy and then again in finance. Before the COVID hit, I was working with the governor's office and with the Office of Strategic Initiatives, potentially to make some changes that would have been done in the House to reflect the progress that had been made with the announcement of the Bureau of Ocean Engineering Management task force, which had been formed and was beginning to meet, and the governor set up some working groups there. So I have, I believe, in a Word document that you will have in the for the committee members is a proposed committee amendment that, after some conversations with the governor's office and with Matt Melou of OSI yesterday, and both parties, we agreed with the final changes that needed to be made to this bill. It does a couple of things. It trims a few people and refocuses some of the appointments on the commission itself. Then it also, because the governor set up his task force, it was felt it would be best not to duplicate those in this body with its own task forces, because it mostly would be the same people on the ones that the governor has set up and what this legislation would set up. So what it does is it says that this commission will cooperate with and work with those task forces, as well as the BOEM federal task force on this. The other substantial change down towards the end of this section is in terms of setting up a fund and how that would be funded. And it felt that it was really premature to do that at this point. We are setting up an Office of Offshore Wind in the Department of the Business and Economic Affairs, and that potentially will have some funding that comes in from grants. So it was thought best to take that out, because it would be probably 3, 4, 5 years before there would be funds coming in that were envisioned through that fund mechanism. So it's best to be silent on that at this point. So essentially, it is the same bill, sets up a commission, has some strategies and goals for it, and lets us move forward on this extraordinary economic development opportunity for the state of New Hampshire. On Senate Bill 248, again, this is a bill that is familiar. On Smoking 21, I introduced it to bring us into conformity with the new federal statute of moving to tobacco 21. And we needed to make some changes in state law to do that. In the House, Health and Human Services brought forward an amendment which also was needed to adjust language in other parts of statute relating to this change. And you also heard today about another language change, which I certainly support as well. So these changes in our statute will bring us into conformity with federal statute and make the changes and definitions that we need. I want to conclude by saying I'm glad to hear that Elsa Rogers of Dover Youth to Youth is on the call and ready to testify, because Youth to Youth and groups around the state have really been supporting this effort from the time it began, actually many years ago. So thank you, Madam Chair, members of the committee, and if there are questions, I'd be happy to take them.
Thank you very much, Senator Waters. Are there any questions from the committee? Senator Waters, I have a question for you. I've received I think it might have been yesterday, a draft amendment to House Bill 1245. Is that the amendment that you're referring to? Or is there been an update since then?
I believe that is the one. Well, there might have been a slightly different version this morning. And so I believe Sarah Paraschino was going to provide that for the committee and copies for the committee members that I believe you were sent today.
Okay. All right. We'll have to check with Sarah just to make sure we've got the right version. Thank you. Thank you, Senator Waters.
And thank you all very much.
Madam Chair, that should be the most updated one. I just resent it to the committee.
Okay. Thank you very much. Okay. Do we have anyone else?
Yes, Senator. We have Representative Cushing.
Okay. Representative Cushing, good afternoon.
Good afternoon, Madam Chair. Thank you very much for allowing me to testify, and thanks to the committee for doing this person's work, taking on 36 separate bills incorporating into this amendment. I just want to say that I'm in support of the section that adds Senate Bill 437. It's virtually identical to a bill that the Criminal Justice Committee passed. It was House Bill 1611. I also am supportive of SB 441 component. I know that the Department of Corrections wants this additional amendment to the trespass law to cover people who stay a little bit too long on their property. And I want to just go on support Senator Waters' SB 668 and the amendment that he's come up with. It's very important. And then finally, just by way of information on Senate Bill 636, authorizing the Commissioner of Safety. I don't have a position on this. I've just been flagged by having some correspondence addressed to my committee, raising some concerns, but I don't have an opinion one way or the other. I just want to flag that there's some concern out there. And with that, I thank you very much.
Thank you very much, Representative. Are there any questions from the committee? Okay, seeing none, thank you very much.
Next, Senator, we have Paula Minahan.
Oh, okay. Good afternoon, Ms. Minahan.
Okay. Paula, are you on the phone?
I believe that's her number with the raised hand.
Thank you. Go ahead,
Thank
Paula.
you. Thank you, Deb. Thank you, Madam Chair and members of the committee. For the record, my name is Paula Minahan, Senior Vice President of State Government Relations with the New Hampshire Hospital Association, representing all our hospitals in the state. We are very supportive of House Bill 1245 as amended with amendment number 1382. And specifically today, I want to focus my comments on sections 88 to 92 of the amendment, beginning on page 36 relative to the Medical Imaging and Radiation Therapy Board. We are appreciative of the work of the board as well as the Office of Professional Licensing and Certification. We had requested some changes to the underlying bill, Senate Bill 729, during the original hearing in late January, and we do appreciate that those requested changes have been incorporated into this amendment that the committee is considering today. And our hospitals have been working under the requirements of the current MIRT law and regulations since the inception of the law back in 2016. And the changes outlined in the amendment ensure consistency with other clinical boards and a more streamlined licensing process that addresses our healthcare workforce shortage. And thank you very much for the opportunity to provide our comments, and I'm happy to answer any questions.
Thank you very much, Ms. Minahan. Are there any questions from the committee? Okay, seeing none, thank you.
The next speaker is Courtney Tanner.
Okay. Good afternoon, Ms. Tanner.
Good afternoon. The timing couldn't have been better. I want to echo a lot of the testimony that Paula Minahan just testified. First, I want to start by thanking Senator Carson for all of the work that you did for our original bill, Senate Bill 729. Thank you so much for your work with the board chair, OPLC staff, and with the hospital stakeholders. As this entire committee knows and understands, licensing is an important prerequisite in our healthcare system, and licensing helps to protect our patients and ensure a quality health workforce. However, over the last couple of years, we've been experiencing some barriers to obtaining those licenses for our professionals governed by the MERT board, and we believe that House Bill 1491, as amended, will remove those barriers and it will allow for the MERT board to operate more efficiently and effectively, including allowing for federal background checks. So I want to thank Senator Carson and for the work of this entire committee.
Okay, thank you very much, Ms. Tanner. Are there any questions for Ms. Tanner from the committee? Okay, seeing none, thank you.
I have Hillary Seeger. Ms. Seeger, are you, if you're on the phone, could you raise your hand? Okay, how about if we go back to her perhaps?
Okay.
13, I have Tyler Clark, please.
Okay. Good afternoon, Mr. Clark.
Tyler, are you there?
Can you hear me now?
Yes.
Hi. Thank you, Deb. Good afternoon, Madam Chair and members of the committee. For the record, I'm Tyler Clark from Preddy Strategies, and I'm testifying on behalf of Diamond Distributors from Meredith, New Hampshire. Diamond Distributors is one of the leading distributors of Lucky 7 tickets sold in conjunction with bingo games. We service over 80 Granite State charities. We are in opposition to Section 151 of the amendment, which was originally House Bill 647, which seeks to increase the maximum price of Lucky 7 tickets from 50 cents to $1. The current language in the amendment could potentially lessen state revenue collected. Right now, Lucky 7 taxes are collected at $15 per deal. A deal is a set of Lucky 7 tickets and contains a maximum of 3,500 tickets. We believe doubling the price of Lucky 7 tickets, which are predominantly sold to an older demographic of seniors who play in our facilities, could decrease the volume sold of tickets, and that would ultimately decrease the volume of deals sold and then lead to less revenue collected by the Lottery Commission. The language in the amendment also doesn't guarantee the charity more revenue. There's currently no language in the amendment to ensure charities will be more profitable if we allow $1 tickets. The entities who will likely make the most money from this change are the gaming consultants who contract with the charitable organizations. And lastly, I would just like to point out that the Senate Ways and Means Committee and the Senate in its entirety passed Senate Bill 528 on February 13th via a voice vote. Senate Bill 528 was amended to allow for a comprehensive study of the charitable gaming industry. And it seeks to study all aspects of charitable gaming, including the costs borne by charities and facilities, revenue distribution, how these facilities compare to traditional casino gambling organizations, and to discuss the potential impact of regulating gaming operators on donations to charities and on tax revenues to the state. Charitable gaming has evolved rapidly in recent years, and further study will help the legislature better understand the industry and the changes it has undergone. For these reasons, I respectfully urge the committee consider removing section 151 of the amendment, which was originally House Bill 647, and I'm happy to take any questions. Thank you.
Senator?
Sorry, yeah, I'm sorry, I had muted. My cat's walking around meowing. Thank you very much, Mr. Clark. Are there any questions from the committee? Okay, seeing none. Again, thank you, Mr. Clark.
Kate Frey or Fry?
Good afternoon, Ms. Fry.
Good afternoon, members of the committee. Thank you so much for this opportunity to testify on HB 1382S, the amendment to 1245. I will be as brief as possible. We are commenting on various sections of the bill. So I first want to express support for previously known SB 248, which is Tobacco 21. We support all efforts to increase this age to 21 for the health and wellness of our children and communities, but also it is federal law. And we're in a tough place with the state because our law is 19. So it does present difficulties for the enforcement to enforce the age at 21. If we don't come into compliance and demonstrate compliance, we could lose federal substance abuse grant funding. So we do appreciate Senator Waters bringing this bill forward and all those who have testified in support. On section 134 to 136, previously known as SB 633, recovery housing, we also support this section as it proposes to take several important steps to support the registration and certification of recovery homes, which we know is critical resource in our battle against the opioid addiction epidemic. Lastly, I'm testifying actually in opposition to previously known bill SB 629, which is sections 137 to 149. This is a bill on specialty beverages. We're opposed to it because it's irresponsible legislation that will increase the accessibility and availability of ready-to-serve cocktails. It allows these spirit-based cocktails such as tequila paloma, rum and tiki rum mai tai to be sold in convenience and grocery stores. That's a monumental shift in New Hampshire's regulatory system, which requires liquor products to be sold in state-run liquor stores. The bottom line again is if this bill were to be passed, it would be increased availability to these products. And we have to remember that alcohol dependence is a burden to New Hampshire, both economically and with health issues. And anytime we increase the access to products like this, we put our residents at risk for alcohol dependence. That's the summary of my testimony, and I want to thank the members of the committee.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
We have Courtney Lindsay. Courtney, are you on the phone? If so, could you raise your hand, please? Okay, I don't see her. So let's go on to the next speaker and perhaps we can go back to her.
Okay.
We have Marissa Chase.
Okay. Good afternoon, Ms. Chase.
Good afternoon, Senator Carson. I think this is the wrong bill. I just wanted to express my support for the text of Senate Bill 444 in the omnibus bill for the alimony changes. And thank you all for everything you're doing.
Okay, thank you very much. Are there any questions from the committee? Seeing none, thank you.
Senator, I believe that is all the speakers that I have.
Okay, I'm going to go ahead and close the public hearing on the amendment, which is amendment number 1392S.
Senator, I don't mean to cut you off. We've missed a number of people that we got hands being raised.
Okay,
Sorry, I'll defer to you, Deb.
thank you. I see them now.
Okay.
We have Marty Mobley.
Okay, good afternoon, Ms. Mobley.
Good afternoon. This is Marty Mobley. I'm the legal coordinator for the insurance department, and I wanted to address a couple of the insurance bills that were rolled into this amendment 1382. I'll first address sections 47 through 52, beginning on page 19, line 23 through page 20, line 21, which was formerly SB 452. This was the insurance department's technical bill, and it really does just make some technical changes to several different bills or several different laws. It corrects a reference. It modifies the punitive fines language so that it mirrors the standard language in our RSA 400A15. It adds language to clarify that fire insurance contracts are for buildings. It removes a word that was inadvertently included into RSA 464 that doesn't need to be there. It's grammatically incorrect. And it repeals RSA 420-N:10, which established the Health Exchange Advisory Board because the Health Exchange now is operated under the auspices of the federal government. So it's not needed in our state statutes anymore. And then the other one I wanted to address was section 42, which it was formerly our HB 1375, and this it clarifies language that says midterm cancellation of commercial policies do not need to have prior approval of the commissioner if these cancellations are caused due to an increased risk in hazard after the policy has been into effect. So I'm happy to answer any questions.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none. Thank you very much, Ms. Mobley.
Thank you. Madam Chair, just 3 more hands that are raised.
Okay.
Lori Warnock.
Okay. Good afternoon, Ms. Warnock.
Can you hear me okay?
Yes, we can.
Wonderful. Okay. Thank you so much for the opportunity to testify on this monstrous creation of legislation. My name is Lori Warnock, and I am the New Hampshire Education Coordinator for the Northern New England Poison Center. I'm testifying today in support of the legislation to raise the age to purchase tobacco to 21 to make the Granite State safer and healthier for our youth. I've spent the last 3 years traveling from Salem to Stewartstown, Claremont to Dover, speaking to high school and middle school students and the adults in their lives about e-cigarettes, vaping, juuling, whatever it is you want to call it. Parents and school administrators, teachers, coaches, and school nurses have been desperate for information for themselves and their students due to the dramatic increase in vaping that they've witnessed. My job is to help them understand what is known and what is not known about these products. We know that most of the juices used in e-cigarettes contain some quantity of nicotine. We know from long history that nicotine is an addictive chemical, addictive in the sense that it creates a compulsive drug-seeking behavior despite negative health consequences. We know that because their brains are still a work in progress, adolescents are at greater risk for exposure to nicotine. This is a scientific fact tobacco companies have relied on for decades. Adolescents become addicted to nicotine more quickly than do adults, and exposure to nicotine during their development can permanently alter the development of impulse control, which makes them more susceptible to other addictive behaviors and substances later in life. Even in those juices that don't contain nicotine, the most common ingredients, propylene glycol and vegetable glycerin, are food safe, but we have no idea if they are lung safe. It will take us years to understand the health effects of these substances on healthy adolescent lungs. It takes most adult smokers 8 to 10 tries to successfully quit smoking. And that is with the knowledge of the serious health consequences of smoking and the assistance of things like patches and gums and prescription medication, most of which are not recommended for use in adolescents, leaving them the least effective strategies to quit. The New Hampshire legislature for the past several years has considered legalizing marijuana for retail sales in New Hampshire. As part of that process, we have carefully defined where and how it is produced, packaged, marketed, and sold. We as a country did none of these things when it came to e-cigarettes. Instead, we allowed the manufacturers to target teens with fun flavors, social influencers on social media and marketing, and easy access like online sales and mall kiosks. Raising the age of sale of tobacco products to 21 is an important step in correcting the damage done by our negligence as adults in protecting teens from this product and the social phenomena it has become. For these reasons, I sincerely hope that you will work to raise the age to purchase tobacco products to 21. Please feel free to contact me if I can be a resource in providing additional information, and I'm happy to take any questions.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none. Thank you very much, Ms. Warnock.
Next speaker is Anika Stanley Smith.
Okay, good afternoon, Ms. Smith.
Ms. Smith, are you there? Okay.
I don't, Deb, I think you brought in the wrong person.
I did.
Hold on. Anika, are you there?
I'm here. Can you hear me?
We got it.
Okay, great. Awesome. My name is Anika Stanley Smith. Thank you to the chair and committee members for this opportunity to speak today about the impacts of raising the purchasing age for tobacco to 21. I'm the Director of Substance Misuse Prevention for the Capital Area Public Health Network. We provide no-cost public health resources for Concord and 23 surrounding towns. My role at the Public Health Network is to support local communities, businesses, schools, nonprofits, police and fire departments, parents and caregivers with the tools and resources needed to prevent substance use disorders. We have evidence-based resources and tools for all ages, but we focus a significant effort in early childhood and youth because it's easier to prevent substance use disorders than treat them. And Lori really broke it down about their development and how substance use in earlier ages leads to substance use disorders in later ages. So the only thing that I want to add to that is that in every year we have something called SINAR, which is where the liquor enforcement goes out and they work with youth who are under 18, currently under 19, who go in and using their real IDs try to purchase tobacco from local stores, so gas stations, places like that sell it. And previously we've had a fairly good grade. We had about a 10% likelihood of the of stores that would sell to underage youth. And recently our grade jumped up to 18%. So there was a significant increase in stores that were selling to underage youth. If our scores reach 20%, then there is a chance that we will lose our federal blockage from the Substance Abuse Mental Health Services Administration. If you're not aware, I'm sure the Department of Health and Human Services could tell you just how much that money is, but it is most of the funding that we have for a lot of the services that we have in New Hampshire for prevention, treatment, and recovery. So I just wanted to bring that to your awareness in case you didn't know about that, and continue saying that raising the tobacco sale ages to 21 is an evidence-based and proven prevention strategy to support prevention, healthy development, and long-term health and safety. So thank you for your time today, and if you have any questions, I'd be happy to answer them.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much, Ms. Smith.
Thank you.
I have Elsa Rogers as the last remaining speaker.
Okay. Good afternoon, Ms. Rogers.
Hello. So my name is Elsa Rogers. I am a upcoming junior at Dover High School, and I'm here in support of the House Bill 248, which is the Tobacco 21 bill. So I'm a member of a program called Dover Youth, which is a youth empowerment program that focuses on drug and alcohol prevention. As a teen, I see firsthand how these products have affected my peers on a daily basis. I have so many friends and classmates who have developed a nicotine addiction from a fad, because the coolness of juuling and vaping will fade with time, but the lasting effects of their addiction won't. So all of the tobacco products are a very big problem in schools because kids are getting their hands on them. But recently, our biggest issue has been e-cigarettes. So our bathrooms have regressed to the bathrooms you see in 50s themed movies where students are smoking in the bathroom, but instead of smoking cigarettes, they are vaping. And these products are discreet and often unnoticed by teachers and staff. And so this only furthers the usage problem. And when one youth in the school gets access to these products, they can easily distribute them to other students. Now, this is where the issue with the current age being 19 comes in. Basically, there are a handful of seniors in high school who are at that age who can buy these products legally. That means they can very easily provide them to younger students, as well as the fact that it is much easier for me, a 16-year-old, to find a friend who is 19 who is willing to buy tobacco products for me than it would be for me to find someone that's over the age of 21. The age of 21 is fact-based, and we know that this will help to decrease the amount of youth who will be dependent on these products for the rest of their life. So although 19 is a step up from 18, it is not fact-based. So that's why it is so important that we do make this change to 21 to help protect the health and safety of the teens in our community, as well as younger students and as they enter into adulthood. Because most people who started smoking before the age of 21. So if we have less teens starting to use these products at a young age, the likelihood that they will grow up suffering from the terrible consequences of tobacco and nicotine are a lot lower. So the passage of this Tobacco 21 bill will reinforce the legislation that was already placed by the US Congress, and it will make it easier for New Hampshire agencies to enforce the requirement to protect the youth in New Hampshire. So thank you for your time. If you have any questions, I'd be glad to answer them. I am not able to hear you, Senator.
I was muted. Thank you very much for your testimony. And are there any questions from the committee? Okay, seeing none, thank you again. Okay, so Ms. Martone, there's nobody else?
That's all I have, Senator, unless there's someone else on the line or.
Okay, Mr. Roberge, is there anyone else on the line? Okay, so we're going to go ahead and we're going to close the public hearing on Amendment 1382S. Okay, the next one up is House Bill 1491. And why don't we go ahead and see, let's see, who is the sponsor? I think Representative Schmidt is the sponsor on 1491. Is he available?
I'm trying to find him. Representative Schmidt, would you raise your hand?
And if you're calling from a phone, you can hit *4 or
Star 9. Star 9.
Star 9. My apologies.
I don't see him on the list. Griffin, do you have any luck?
No, I don't see him, and yeah, I don't see anybody.
So Senator, you may want someone just to introduce it.
Okay, well, I will do that for the committee. I'd like to introduce House Bill 1491, an act relative to allied health professional temporary licensure. And this bill expands the professions in the allied health governing boards, which grant temporary licensure to licensees from other states. Okay, do we have anyone who would like to testify on the bill?
I had him as the only speaker.
Okay, since we don't have any other speakers, I will go ahead and close the public hearing on House Bill 491. And I will open the public hearing on, let's see, Amendment 1388.
We have Senator
S.
Gaida has his hand raised right now.
Well, we've already closed the public
Okay.
hearing, so I guess he wants to speak first on the amendment.
I think Senator Gaida might want to speak on the amendment. I think he just prematurely raised his
Okay.
hand. I think, yeah, he'll come in after.
Okay, so we're going to go ahead and recognize and we're going to open the public hearing on the amendment to House Bill 1491, which is 1388S. And I would just like to read into the record the number of bills that comprise this amendment. The first is Senate Bill 576, which is revising the authority of boards and commissions for technical and health professions regulated by the Office of Professional Licensure and Certification. House Bill 1491, of course, is the vehicle for the amendment. House Bill 676, relative to the Controlled Drug Prescription Health and Safety Program. House Bill 1188, relative to conditions of allied health professionals. Senate Bill 432, relative to the definition of licensing agency for purposes of licensing places of assembly. And House Bill 1599, establishing a special marriage officiant license. And I will recognize Senator Rosenwald to introduce the amendment.
Thank you, Madam Chair. I would like to offer Amendment 1388S as a substitute for 1385S. It adds, as you said, several licensing bills to the underlying subject matter of temporary licensing. It makes 1388 makes only one change to section 180. That's the only way it's different from 1385. Two of the bills that are part of this omnibus are from Senator Gaida, and he's here. One is Senate Bill 576. He refers to it as his Tolstoy bill, and it is the length of War and Peace. It standardizes many of the administrative functions of the Office of Professional Licensure and Certification. And we heard this bill here in committee earlier in the winter. The mistake that 1388 corrects is to fix the fiscal impact by staggering the biennial licensing, but it was inadvertently left out of Amendment 1385S. This amendment also contains language that Senator Gaida and I worked on with OPLC to address streamlining the licensing process for healthcare workers by incorporating two of the governor's executive orders. One enables electronic signatures, and the other allows OPLC to issue temporary licenses while the boards are considering license applications. The parts of 1388 that relate to the prescription drug monitoring program, I believe it's sections 313 to 317, restrict the original subject matter of Senate Bill 676 to OPLC and leave the Department of Health and Human Services sections to be addressed in future legislation. This was worked on by Senator Gaida, Senator Sherman, and me with OPLC. I think that explains what's in 1388, and thank you, Madam Chair.
Thank you very much, Senator. Are there any questions for Senator Rosenwald. Okay. Senator Rosenwald, I have gotten a proposed amendment to the amendment from the Board of Electricians, and they would like to offer some language concerning their board and dealing with the quorum of the board. And what they would like to change it to is to say a majority of the members of the board appointed by the governor and council, one of whom shall be a public member. So they just want to make sure that that a public member is would be counted as amongst the quorum of the board. So I will be talking, I guess, about that maybe later. So I just wanted you to know that I've gotten that.
Thank you, Madam Chair, for letting me know.
Okay, are there any other questions from the committee? Okay, seeing none, why don't we go ahead and open it up to the public?
Madam Chair, Senator Gaida.
Okay, thank you. Good afternoon, Senator Gaida.
Good afternoon, Madam Chair, members of the committee. Thank you for taking my testimony. For the record, Bob Gaida, State Senator, District 2. Here in full support of the Senate Bill 576 and 676 amendments to 1491. Specifically, 576 is the result of an incredible effort by Acting Executive Director Lindsay Courtney of OPLC. Since 2016, when OPLC was in fact put into existence, we've been struggling to get the administrative procedures, processes, and funding mechanisms in place to make OPLC work as the legislature intended. This document does that. It may not be complete, but in its length, it covers just about every possible change that was needed to accomplish that mission. And so for those reasons, I would ask the committee to vote in the affirmative on this particular amendment. With respect to the 3 amendments to the bill proposed by Senator Rosenwald, I'm in full consonance with them. She was very astute in capturing specifically the 3rd amendment, which deals with the scheduling of the renewals, and will save the state considerable money. I think in the amount of $700,000. If we enact that, it will cost the state that $700,000 if we don't. So again, all 3 amendments are really good and necessary for improving the service given to our citizens and our businesses by OPLC. And I would ask the committee to vote in favor of all 3 plus the bill as amended. Thank you.
Okay, thank you very much, Senator. Are there any questions from the committee? Okay, Senator Gaida, I just have a quick question for you about the request from the electricians, just to change just a sentence within their section on organizations and meetings that says that the quorum shall be a majority of the members of the board appointed by the governor and council. The new language would read, one whom shall be a public member. Do you have any objections to that?
Thank you, Madam Chair. No, I do not. And if I may return to Senate Bill 676, it needs to be noted that DHHS through John Williams was in consonance with the amendment that removes them from the access. They are important enough and in fact complicated enough that will require separate legislation, and we have pledged to go forward with that. Thank you, Madam Chair.
Okay, thank you. Any further questions from the committee? Seeing none, thank you very much, Senator.
My pleasure.
We have Lindsay Courtney.
Okay, good afternoon, Ms. Courtney.
Can't find her.
I'm here. Good afternoon, Madam Chair, members of the committee. For the record, I'm Lindsay Courtney. I'm the Interim Executive Director of the New Hampshire Office of Professional Licensure and Certification. OPLC fully supports HB 1491 and Amendment 1388S. You know, we've already spoken, of course, about the Tolstoy bill earlier in the year. So I'm just going to go over the highlights of that. And if you have any further questions, you know, feel free to let me know. But of course, the primary objectives of this amendment are to remove language from certain practice acts that conflict with OPLC's authority to establish fees across all boards, establish OPLC as a 125% agency, remove the requirement in certain practice acts that require a court stenographer to be present. That's from an efficiency standpoint. Grant to the executive director the authority to set per diem rates to ensure efficiency as well. Standardize quorum requirements, repeal RSA 332H, add the Board of Veterinary Medicine to OPLC statute, which is RSA 310A, remove references to the Commissioner of the Department of Health and Human Services, where many of our boards were previously located. Remove the requirement in certain practice acts that boards provide a roster of licensees. Permit the agency to adopt a retention policy, and we're coming into we're having issues with this now. We have paper everywhere, so it'd be nice to adopt a retention policy in consultation with the archivist. Clarify that OPLC does not have reporting requirements under 332G13 for certain boards that don't fall within the agency. There are a few Title 30 boards. I think the Board of Mechanical Licensing, that doesn't fall under OPLC. RSA 332G essentially would require us to perform certain functions, including licensing. So we want to make that clear. Grant the executive director the authority to promulgate rules for all boards that participate in the professional health program, as opposed to 5 separate sets of rules. Set term limits for the family mediator certification. Change term limits for the PDMP program. Clarify that the executive director, not PDMP, has access or authority over certain tasks. And the next 3 pertain to the amendments that were recently worked on by Senator Rosenwald. Establish provisions for temporary licensure to increase portability of licenses. What we have seen through the COVID emergency process is that we are able to, OPLC as an agency and not the individual boards, are able to provide temporary emergency licensing to individuals out of state, provided they provide very minimal documentation of having a license in another jurisdiction that's in good standing. And we've been able to leverage technology such that we can turn around a license in 24 hours. And this allows providers to start practicing immediately. And to the extent that it takes time for providers to obtain a full permanent license, it allows them to work while that license process is underway. So I think this is very important that this continue even after the state of emergency ends. To that end, we're also requesting as part of this amendment to permit OPLC to allow electronic signatures on licensing applications. This again was part of an emergency order, but what we found as a practical standpoint is there are certain statutes that require boards have a wet signature. Obviously that's not conducive to work in 2020. And what we're looking to do over the next year is to really leverage technology and get everybody applying for licensure online so that I don't have the filing cabinets throughout my building. It's a much more efficient way to make things happen. And so we're requesting that we can accept electronic signatures. And finally, we would like to modify the biennial licensing schedule of pharmacies to ensure consistent revenue. As we discussed previously, last year in the last legislative session, the legislature adopted a statute that changed pharmacy permit renewals from annual to biennial in odd years. And OPLC fully supports biennial renewals. That makes things a lot more efficient from an administrative standpoint. But unfortunately, around the same time, HB4 was adopted, which changed OPLC's dedicated fund to a non-lapsing or to a lapsing dedicated fund at the end of every fiscal year. So by virtue of that, pharmacy renewals account for a sizable portion of OPLC's budget, and the combination of that change meant that without this proposed amendment, OPLC will lose approximately $729,000 in the next fiscal year. So what we're proposing in this amendment is to keep biennial renewals, but to split that up, to have half pharmacies renew in odd years and half of the pharmacies renew in even years. And this would, of course, ensure a steady revenue stream each year and avoid the problem that we're facing in terms of the loss of revenue. In terms of 676, OPLC fully supports that portion of the amendment to 1491. Section 4 of the prior bill would permit the office to enter into agreements with healthcare facilities to permit the PDMP to interface with electronic health record systems to allow practitioners to query the PDMP directly from the EHR. I think it's important to note that the legislation does not expand practitioner access to PDMP, but it streamlines existing access. And there are only 9 states that do not presently permit access to PDMP data via integration with either a health information exchange, electronic health record system, or pharmacy dispensing system, or a combination of those systems. So we'd like to enhance provider access and encourage provider use of the PDMP system by rendering it easier to do so through an EHR system. I'm happy to take further questions if you have any. Thank you.
Thank you very much, Ms. Courtney. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
The next speaker is Representative Cushing.
Okay. Good afternoon again, Representative Cushing.
Thank you very much, Madam Chair. For the record, I'm Representative Rennie Cushing from Rockingham 21, and I'm here to support the amendment. And in particular, I wish to speak in support of House Bill 1599, establishing a special marriage officiant license. This should be familiar to people as it's been the subject of legislation in the past. This does 2 things. One, it provides a special license for marriage officiants for one time. It's akin to what's done in other states, Vermont in particular. And it just allows more flexibility for the marriage process and planning, and we know that we'd like to encourage that. And the other thing it does is it uses the proceeds, portion of the proceeds of that to go into the domestic violence fund. And that's it, pretty straightforward. It maintains the New Hampshire advantage. The Vermont license is $100. This would be $90. And it got pretty far last time. It kind of fell apart at the last moment in a conference committee.
Thank you very much, Representative. Are there any questions for Representative Cushing? Okay, seeing none, thank you very much.
Paula Minahan.
Okay, thank you. Good afternoon, Paula.
Wait. Hold on.
Sorry.
That's okay.
Good afternoon, Ms. Minahan.
Got it.
Okay. Good afternoon, Ms. Minahan.
Thank you, Senator, and thank you, Deb. Again, my name is Paula Minahan. I am the Senior Vice President of State Government Relations for the New Hampshire Hospital Association, representing all our hospitals. We are very supportive of House Bill 1491, and specifically as amended by Amendment 1385. I have not seen Senator Rosenwald's amendment, but she did explain it well, and we don't have any we don't have any issues with 1388 changes. Today, I will focus my comments on sections 101 to 106 relative to the Medical Imaging and Radiation Therapy Board, sections 197 to 199, and 313 to 316 relative to the Controlled Drug Prescription Health and Safety Program, and sections 219, 308 to 312 relative to temporary licenses. So regarding MIRT, sections 104, page 22, lines 36 and 37, we do request the following amended language, and it's very brief. I did send this via email, so you do have my written testimony. And remove at least 24 hours of board-approved continuing education during each license period and replace it with, quote, the continued education as required by the National Credentialing Board governing the respective profession. This change is needed to ensure that all various professions, national credentialing and registration, organizational oversight that fall under the jurisdiction of the MIRT board, which are pretty extensive, I think you're aware of that, are contemplated in this continued education statute. The change also reduces the administrative burden of each medical imaging and radiation therapy professional by aligning their national credentialed continuing ed requirements to support the New Hampshire license. On the PDMP, we are very supportive of these sections, which I highlighted earlier, as they incorporate the provisions of Senate Bill 676 that was sponsored by Senator Gaida, and which we supported when it was originally heard and passed in the Senate. We do not actually have a comment on the DHHS section, and we did not during the hearing as well. We were focused on the electronic medical record interface, which Ms. Courtney explained earlier. Temporary licenses, sections 219, 308 to 312. The language added to the amendment supports the current governor's emergency orders, numbers 15, number 46, and number 29, Exhibit H, allowing for temporary licenses and the electronic signatures. This language will be very beneficial to all licensed professionals overseen by OPLC, and we strongly support including this language in the amendment. Temporary, yes.
I just wanted to let you know that we have reached 3 minutes. If you
Okay, thank you very much. And that is it. You have my written testimony. Thank you, and I'm happy to answer any questions.
Okay, thank you very much, Ms. Minahan. Are there any questions from the committee? Ms. Minahan, I have a question concerning the education portion of what you are proposing. I'm looking at the amendment to 1491, and there's on page 22, section 10, beginning on line 13, it just says that the standards for educational program is approved by the board. I think what you're asking for might, I'm not sure how the board would feel about this. Have you talked to them about this?
This did get raised. I mean, the timing is, a little awkward because they also were updating their rules, the 400 rules, and we did testify. It was probably a week or so ago when the rules hearing occurred, and we did request that this change be made. My colleague, Kathy Bizarro-Thunberg, did testify, and let me see, that was just on June 3rd that we asked for that. And what we learned was that there's almost a matrix, and it gets really confusing because all these different boards, if you're a stenographer, or a rad tech, your continuing ed requirements vary quite a bit. I do know also my colleague from Dartmouth-Hitchcock, Courtney Tanner, I believe, will be testifying, and she also testified at the hearing. So I think she can maybe elaborate a little bit more. But we do have written testimony submitted for the rules. And I understand that our understanding was this needed to be changed in statute. I cannot obviously speak for the board, and I do not know if they had any concerns about this. Maybe someone from the board plans to testify, but we were just concerned that it was really burdensome, that we have some that are every year, some that are every 3 years, some that are every other year. It's really confusing. So we're just trying to align it with their national credentialing requirements.
Okay, I see Senator Reagan has disappeared because he's on GELCAR and he would know about the rules. Senator Reagan, did you discuss this in rules? Senator Reagan? Can you hear me?
Yes, I can hear you. I believe she said at the hearing, but it wasn't at GELCAR.
Oh,
Senator Reagan's right. Yeah, yes, sorry, I was not clear. The hearing in front of the board on June 3rd. So Senator Reagan's right. It has not made it to GELCAR yet.
Okay. All right. Thank you. I saw Senator Rosenwald had her hand up.
Thank you, Madam Chair. I just had a question for Paula. Is this part about the continuing education, is this really time sensitive, or is that something that could be looked at in the next session as a bill and get a full hearing on?
That is a good question, Senator. It may make it a little difficult for those that are trying to fill this requirement now, and it's not matching up with their national accreditation. I can't completely answer if it's that time sensitive. Can we just hold that question for Ms. Tanner to see if she could maybe answer it a little bit better? But I understand what you're saying, I will defer to the committee, but I completely understand what you're saying.
Do you have a follow-up, Senator Rosenwald? Okay, thank you. Are there any further questions from the committee? Okay, seeing none, thank you.
Thank you.
Courtney Tanner?
Can you hear me?
Yes.
Oh, good afternoon. This is Courtney Tanner from Dartmouth Hitchcock. Thank you very much for the opportunity to testify. I am going to jump right to the piece about the requested amendment. Thank you, Paula, for putting forward the requested amendment to page 22, line 36, 37, striking at least 24 hours for the board to approve continuing education during each license period and replacing that language. Senator Carson, I did have a chance to email the board administrator who shopped the proposed amendment with the board members. The board has not taken a formal position because they haven't met to vote on the language, but the language was well received. Even Brandy, the board chair, commented positively about the amendment. Specifically, this amendment to the statute would allow the board to promulgate rules that would help each profession parallel their national requirements. So this amendment actually gives the board a little more power to tailor their rules to each profession that it oversees. Senator Rosenwald, to answer your question about timing, I completely appreciate that this has been, you have done so much work to put forward these big omnibus amendments. The reason why that this would be time sensitive is because the rules are being contemplated right now at the board level, and without the statutory change, they'd have to reopen rules again. So that's the only time constraint that I can think of right now. So I just want to be completely transparent about that piece of it. I'm happy to answer any questions about our suggested amendment. I'm sorry to have thrown this in at the last minute, but we just found this statutory issue just last week, as Paula mentioned, when these rules were published. So.
Okay, thank you for your testimony. Are there any questions? I have to say I'm a little concerned about this. By getting something like this at this point in time. This bill had a full public hearing in front of the Senate ED&A committee. It was passed. No one reached out about anything until Ms. Minahan sent an amendment, and Senator Rosenwald did a lot of work on putting all this together. I don't feel we have the time to even consider that type of an amendment. You just really kind of, blindsided, I think is probably a good word, us with asking for this change. And I really would like to hear from the board and see what the board thinks about this before we move forward. And I don't know if we even have enough time to do that. Senator Rosenwald, how do you feel about this?
I totally share your concerns, Madam Chair, and on the same aspect of this amendment. I just feel like this is a pretty significant policy change that I would like to have time to get input from the affected parties. I don't know anything about these certifying organizations. I don't feel like I know enough about it.
Okay, thank you. Are there any further questions for Ms. Tanner? Okay, seeing none, thank you very much.
Madam Chair, Senator Waters has his hand raised.
Okay, Senator Waters.
Thank you, Madam Chair, members of the committee. Senator Waters, District 4. I very briefly wanted to comment on the part of the amendment, which is Senate Bill 591, establishing a statewide solid waste disposal reduction goal. This bipartisan legislation came from the Solid Waste Management and Recycling Committee chaired by Representative Ebel last summer. It has the full support of DES, waste management, and landfill operator, and so forth. The only reason I'm testifying today is just to assure this committee that I have spoken with DES, given the circumstances about their undertaking this, and they said that indeed they thought that this should be done now. We should pass this, and particularly I would like to note that the issues about solid waste and our landfills filling up, and also the issues about recycling, which have been caused by what has happened in the pandemic and has caused to that recycling market, that this seems especially timely. So that's all I wanted to say, and I am happy to take any questions.
Thank you very much, Senator. Are there any questions from the committee? Okay, seeing none, thank you again.
The last speaker is Pamela Keelig.
Okay, good afternoon, Ms. Keelig.
Hi, good afternoon, Madam Chair and members of the committee. For the record, my name is Pamela Keilig, and I am the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. I am here in support of the amendment to HB 1491, and specifically want to speak to the provision that was previously referred to as HB 1599, which Representative Cushing mentioned a little bit earlier. I just want to briefly speak to one aspect of that provision, which is that part of the fund or the fee from the special marriage officiant license would go to the Domestic Violence Prevention Fund. And I just want to echo how important that fund is, and that this is continuing important precedent that was set decades ago under the first marriage license fee. And just briefly, the DVPP provides funding for many critical life-saving services that include emergency shelter, services for traumatized children, and the operation of our 24-hour hotlines. And it's really critical that the crisis centers are able to respond with the services needed and with a commitment to keeping victims and their children safe. Noting that unfunded programs should never be the reason a survivor is denied access to safety. To emphasize why this fund is so important, in 2019, we served over 15,000 victims, including 440 shelter guests who spent over 40,000 nights in shelter. However, even with the funding from the current DVPP and marriage license fee, crisis centers have still had to turn away folks due to lack of capacity. So this would further help us be able to serve the population of New Hampshire. And I just want to emphasize that because of the context that we're in, the pandemic has had a profound impact on financial stability, household income, and access to healthcare and other social services. So we must recognize the fact that victims of domestic and sexual violence who are already in a state of crisis prior to the pandemic will remain among the most vulnerable, even as communities open back up. So I just thank you so much for hearing me today, and I urge you to pass the amendment to HB 1491. I'm happy to answer any questions.
Thank you very much for your testimony, Ms. Keilig. Are there any questions from the committee? Okay, seeing none, thank you again. So is that the end for 1491?
I believe so, Senator.
Okay, I am going to go ahead and close the public hearing on amendment number, I think it's 13, I put it away already. 1388, I believe it is, 1388S. Okay, we have one more left to go. Thank you all for hanging in there. I think we had the most bills than anybody else in these omnibus bills, but that's okay. We're a tough committee. We'll get the job done. Okay, I'm going to go ahead and open the public hearing on House Bill 1234 and recognize the prime sponsor, Representative Wallner.
Representative Wallner, I am trying to find you.
Your hand is raised.
Thank you. Go ahead, Representative.
Thank you, and thank you for being here. It's really interesting to see all of you in this venue. House Bill 1234, I brought in seems like years ago, but it was last in the fall. And what it pertains to is the heating system that all of us are familiar with. You've seen all the work over the last several years. In June of 2016, Concord Steam announced that they would cease operations before the next heating season. And this put the state government, as well as many entities in Concord, in a very, very difficult situation. In 2017, the legislature approved an $18 million appropriation supplemented by $7 million from the capital budget to develop new heating system for state office buildings on the State Office Park campus and scattered around Concord, including the State House. The original $18 million appropriation was scheduled to lapse on June 30, 2019. The project is within the budgeted amount, but not yet complete. So the project was not completed by June 30th, 2019, but we were still within the budget. We were still within the budgeted amount. Both the governor and the legislature had agreed to extend the lapse date another biennium to use the remaining 2.1 million to finish the project. Although not a bone of contention in the budget, that language was inadvertently left out of the final budget compromise, and the $2.1 million lapsed. This bill does not increase the cost of the project. It would merely restore the lapsed funding and also the language regarding paying back the appropriation from the savings generated from reduced operating costs. It's an important bill in that it would allow us to get this project done. And I believe that there are people on the call, I think, from Administrative Services can update you exactly where the project is at this time. And thank you for consideration of the bill.
Okay, thank you very much. Deb, do we have any folks that would like to testify on House Bill 1234?
Yes, Madam Chair. Brian Moran.
Good afternoon, Mr. Moran.
Yeah, good afternoon. Actually, I may have made an error when I signed up. I'm interested in 1371S, which is an amendment, which I think you're going to hold hearing a little bit later.
Right after this one.
I will yield and stand by.
Okay, thank you very much.
Thank you.
All right. How about Robert Wells?
Good afternoon, Mr. Wells.
My name is Robert Wells. I live in Hopkinton, New Hampshire. I'm an attorney at the McLean Middleton firm, and I'm here speaking on behalf of a large group of trust and estate attorneys who have worked with Judge King and with others with respect to matters relating to state administration, power of attorney, as well as the Disclaimer Act. And let me be brief because I know your time is short. Perhaps most importantly, from the probate court's perspective, is the new waiver of administration bill, which now will allow the court to have reduced number of estates that have to be probated because it expands the number of cases where we can have.
Mr. Wells?
Yes?
Mr. Wells, excuse me. I think you want to testify on the amendment because the bill the bill is about the heating of certain state-owned buildings in Concord. I think the bill you want to testify is within the amendment.
Yes, but I don't think you're ready for me to testify to that, are you?
No, we haven't even introduced the amendment.
Okay, I'm sorry you called upon me and I was trying to respond.
Nope, that's okay. We're all new to this. This is okay.
All right. I will wait my turn.
Okay, thank you very much.
Absolutely.
The next speaker is former Representative Finney.
Okay, thank you. Representative Finney.
Representative?
I think he probably would like to testify on the amendment as well, because there are a number of animal bills in there.
Representative?
Okay, let's see
All
who
right.
else is there.
We'll go on. We have Stephen Robbins.
Okay. Good afternoon, Mr. Robbins.
Hold on. Mr. Robbins, are you on the phone? Mr. Robbins? I have Representative Finney back, or former Representative Finney.
Okay. Representative Finney.
Yes, hello. Can you hear me?
Yes.
Just
Oh, yeah.
barely.
Oh, well, let me sit up. I'm about as unused to this as you all are. Actually, I would like to speak against the amendment with reservations, if that'd be all right, and I can wait till then.
Yeah, we haven't introduced that yet. We're still on the 1234. And this is about the heating of certain state-owned buildings in Concord.
That's exactly right. I agree. Thank you, Madam Chair. So I will reserve my comments until you bring the amendment forward.
Okay, thank you.
Thank you.
And I have Mike Summers.
Mr. Summers?
Yes, hi. Madam Chair, I inadvertently registered for the original bill, and I'd like to speak to the amendment as well, so I will yield my time.
Okay, thank you very much.
Senator, I believe that's all I had for speakers for the underlying bill.
Okay. All right, so we're going to go ahead and close the public hearing on House Bill 1234. And before we have Senator Rosenwald introduce the amendment 1371S, I'd like to go ahead and read all the bills that were put into this amendment. First, we have House Bill 1234 relative to the heating of certain state-owned buildings in Concord and making an appropriation therefore. Senate Bill 423 relative to the election of Charter Commission members. House Bill 1259 relative to the rulemaking authority of the Department of Information Technology. House Bill 1326 requiring the Independent Investment Committee of the New Hampshire Retirement System to report investment fees. House Bill 1377 making a technical correction and a clarification in the law governing death benefits for emergency medical technicians and rescue squad members. House Bill 1407 relative to adopting rules relative to department forms. House Bill 1437 relative to the qualifications of the banking department commissioner and deputy commissioner relative to consumer complaints and relative to applications for money transmitters. House Bill 1627 creating an animal records database. House Bill 1695 relative to background checks for certain persons under the banking law. House Bill 1702 establishing a solid waste working group on solid waste management planning. House Bill 1704 relative to compost. House Bill 1714 relative to ratification of amendments to the state building code and state fire code. Senate Bill 757, local option for operation of sport book retail locations. Senate Bill 414 relative to roads within the Woodsville Fire District. Senate Bill 512 relative to transportation of beverages and wine. Senate Bill 557 relative to the Advisory Council on Career and Technical Education. Senate Bill 592 relative to the Pease Development Authority Board of Directors. Senate Bill 635 establishing the Lakes Region Development Authority with Amendment 1123S. Senate Bill 746 relative to the Charter for Brewster Academy. Senate Bill 525, relative to probate administration, distribution upon intestacy and powers of attorney. Senate Bill 571, relative to the Uniform Disclaimer of Property Interests Act. Senate Bill 692, relative to certain costs of the Public Utilities Commission for participation in regional activities. Senate Bill 460, relative to enforcement of zoning violations. Senate Bill 444, amending the alimony statute due to changes in federal tax law. Senate Bill 669, relative to authorization to grow industrial hemp. Senate Bill 575, relative to appeals from the Victims Assistance Commission. Senate Bill 591, establishing a statewide solid waste disposable reduction goal. Senate Bill 540, repealing the Emergency Medical Services Personnel Licensure Interstate Compact. Senate Bill 626, decreasing the fee to file a petition for declaratory ruling with the Site Evaluation Committee. Relative to the definition of House Bill 496, relative to the definition of antique snowmobiles, relative to water quality rules, and relative to the disposition of administrative fines for asbestos management violations. House Bill 311, relative to the authority of the state fire marshal to grant exemption from fire code requirements to recovery houses. House Bill 1518, relative to the alternative compliance payments for renewable energy obligations not met through the purchase of renewable energy credits. House Bill 1592, relative to milk pasteurization. House Bill 1347, addressing impacts to other water users from new sources of water for community water systems. And finally, Senate Bill 456, relative to the use of capital reserve funds. So I'm going to call upon Senator Rosenwald to introduce Amendment 1371S.
Thank you, Madam Chair. Again, I'd actually like to also introduce Amendment 1407, which I think you all have. It's a correction to Senate Amendment 1371. Both of these amendments add a number of bills, as you just read, to the underlying Concord STEAM. And these policies are really all necessary to ensure the efficient functioning of state and local government entities. All of the material within has been at least heard by either the House or the Senate, with the sole exception, I believe, of voting on retail locations for sports betting. This is section 48. This language was originally in Senate Bill 757 and scheduled for Senate hearing on March 18th, but then the shutdown began. This section puts the cities on equal footing with the towns in terms of when they can hold a vote, and I believe the mayor of Nashua has signed up to speak on this section. Amendment 1407S, which I would like to offer in place of 1371, corrects the language to the Animal Records Database section. It includes the most current language of the Charter Commission section, the language of Senate Bill 498 on electrical energy storage, revised language on OHRV and snowmobile registration from the department, and a revised definition of rental facilitator for the rooms and meals tax. Thank you, Madam Chair.
Okay, sorry, I was looking for my phone because I want to get a copy of that amendment. I don't have it. Okay, thank you very much, Senator Rosenwald. Are there any questions from the committee on proposed amendment 1371S? Are you telling us that amendment 1407 replaces the whole of 1371? Yes. Okay.
Yes.
Okay.
I'm very sorry. I thought it had gone out to the committee.
Yeah,
earlier
I don't have a copy of it. I had asked Mr. Lapine to look for them all this morning to make sure that I had them all. So that's okay. We'll figure it out.
If I could figure out a way to share it.
I think probably Mr. Raff would probably be able to do that.
Posted on the general court website under the meeting.
Okay, hold on. Let me pull up my computer.
I'm sorry.
I can also send it to all of you.
Okay, because I'm looking at, okay, the general court website and our hearing. Okay, I do see amendment 1407S, so it is updated. Okay. Okay.
Okay, Madam Chair, our first speaker is Colleen Smith.
Okay, Ms. Smith.
Good afternoon, members of the committee. My name is Colleen Smith. I'm with the Department of Health and Human Services Food Protection Section, and I'm here to speak today on the amendment. In particular, this is with regard to House Bill 1592 relative to milk pasteurization. The department would like to propose the following changes to lines 32 and lines 35 of this bill. And this is with regard to the original intent. As we had met with the sponsor, Representative Allard, Representative Aaron, Commissioner Jasper of the Department of Agriculture, members from the New Hampshire Farm Bureau, UNH Cooperative Extension, and the constituent whose bill this was filed on behalf, is the intent was just to add ice cream and frozen yogurt to this exemption and not open it up to other raw milk products or frozen desserts. And so that is why the department would like to have those changes noted. This has been sent to the committee yesterday, or actually it might have been this morning that it was sent to the committee.
Okay.
Happy to take any questions.
Thank you. Thank you very much. Are there any questions from the committee? Okay, seeing none. Thank you.
I have Senator Waters, if I can find you. Are you on the phone, Senator Waters? Guys, do you see Senator Waters?
I think he might have gotten off, Deb. I don't see his name here any longer.
Okay, thank you. How about Representative Wallner? Let me try to find her.
I got
There.
her.
I got her. Thank you.
Representative Wallner.
Thank you very much, Chairman Carson. I don't need to speak to the amendment. Thank you.
Okay, thank you very much.
Thank you.
Okay, how about Representative Cushing? Let me see if I can find him. Bear with us, folks.
Deb, I don't see him on the list either.
Okay. Well, how about Mayor Donchis? I know he's on here.
I got him.
Thank you.
Okay, good afternoon, Mayor.
Can you hear me?
Yes.
Well, thank you, Madam Chair and members of the committee. I am appearing, so to speak, to testify on behalf of the portion of the amendment that would authorize cities, as Senator Rosenwald said, to put the question of sports betting in physical locations on the ballot more than once. We have a couple of locations here in Nashua where there is charitable gaming, and those locations contribute massive, but a lot of money, millions of dollars over several years to nonprofits, charitable organizations across the region, and are a very important source of support. Now, of course, those sources of support have been lost, at least temporarily, during this
pandemic because they're not open. But the allowing them to potentially host sports betting would not only strengthen them, but make it possible for people who would come in to do the sports betting to also play the charitable games that support the nonprofits. And I would just note that this wouldn't really result in any kind of expansion of particular large expansion of sports betting, because anybody can sports bet any place they want, remotely, on the phone, at their house, at either of these locations, via the internet or a cell phone, as long as they have an account. And this would simply make it possible for these venues to host live, sports betting where people are there and make the bets right there with them. And so we'd like to help strengthen these sources of support for the nonprofits. We did put it on the ballot. It wasn't very well understood, I don't believe. It almost passed. It was like somewhere between 50 and 100 vote gap out of 10,000. And so and it was not well understood in my view. A typical comment was, someone at the polls said, I thought sports betting was illegal. In other words, they didn't really realize it had been legalized, and this was sort of a refinement. In any event, I'm sure the committee understands the issue, and therefore I will conclude my remarks and just ask for your support. And if you have any questions, of course, I'm right here.
Thank you very much, Mr. Mayor, for your testimony this afternoon. Are there any questions from the committee? Seeing none, thank you very much.
Thank you. Bye-bye.
Senator Sherman?
Can you hear me?
Yeah, we sure can. Good afternoon, Senator.
Good afternoon. How are you all doing? Well, I won't ask that. But anyway, I hope you're doing well. For the record, my name is Senator Sherman, Tom Sherman, District 24. And I am testifying on behalf of the Peace Development Authority component to the amendment. Does everyone know which part I'm talking about?
Yes, we do.
Perfect. And as the chairwoman knows, this is a correction from last year. We added a half representative from Greenland. And in that compromise, the language was not corrected in another part of the original bill, which went into the correcting amendment. And so we ended up with a problem with the Peace Development Authority board and their quorum. And this part of the amendment fixes that. And without this fix, they will not be able to function because the numbers will be wrong. So it is a completely technical correction based on last session's work, and I hope you all will pass it. And I'm happy to answer any questions.
Thank you very much, Senator. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you, Madam Chair.
Okay, we have Representative Packard. If I can find you.
Deb, he was there a second ago, but
I
I
know.
don't see him anymore.
Okay, okay. All right. Bear with me, Madam Chair.
Yeah, we're good.
Okay. We have Henry Bayou. And Henry, I'm trying to find you on the phone list.
I got him.
Thank you.
Okay, good afternoon, Mr. Bayou.
Yep.
He's muted right now.
You hear me now?
Okay. Yes.
Okay. Thank you, Deb, for recognizing me, missing you and members of the committee at the State House. But for the record, my name is Henry Gayu, and speaking this afternoon on behalf of Waste Management, which has a landfill facility in Rochester. And I'm specifically speaking to sections 86 and 45. As Senator Waters mentioned, these solid waste provisions are the product of a study committee that met last summer and fall that he and Representative Ebel led. This section 86 is Senate Bill 591, which passed the Senate on a voice.
Did we lose Mr. Bayou?
I believe we may have. Henry?
Oh,
Okay,
just lost him.
yep, okay. Let's
Oh,
go on.
Hold on.
Oh, he's back.
I'm back.
Okay.
Hey, okay.
So section 86 is Senate Bill 591, which passed the Senate on a voice vote on March 12. And it specifically addresses the solid waste reduction goal. The current goal has never been met, and we are far from meeting it, largely because the formula for figuring it out includes a lot of waste which cannot be recycled. So the version that you are looking at in this bill addresses those solid waste that can be recycled, and we obviously want to encourage recycling rather than landfilling. The other provisions, section 45, is House Bill 1702, which passed the House on March 11th. And that sets up a solid waste working group to prepare for future solid waste challenges. So we also support that. So, with that, I'll conclude my remarks. But we support those two provisions, and thanks for giving me the opportunity to speak.
Thank you very much, Mr. Bayou. Are there any questions from the committee? Seeing none, thank you all. Thank you very much.
Brian Moran?
Okay. Good afternoon, Mr. Moran.
Good afternoon, Madam Chair and members of the committee. My name is Brian Moran. I'm Director of Government Affairs for the New England Convenience Store and Energy Marketers Association. We represent single-site convenience store and gas retailers, chain convenience stores, and independent transportation fuel distributors and businesses which supply them. According to the National Association of Convenience Stores, there are almost 900 convenience stores in New Hampshire and 655 which sell motor fuels, employing over 14,000 people and account for almost $3.8 billion in sales per year. We'd like to share our concerns with proposed amendment that would allow on-premise licensees to sell beverages and wine for takeout food with a takeout food order. It's on page 17, line 34 of the bill. Amendment number 1371S. These past several weeks and months have been very difficult for most businesses. Despite being designated as essential, convenience stores and gas stations have had their share of challenges, including restrictive operating guidelines, dramatically reduced traffic, and added cost to ensure the safety of our employees and customers. The restaurant industry's challenges have been severe and well documented, and Nexima certainly sympathizes with the impacts COVID-19 continues to have on their industry. We did not object to allowing beverages and wine to be sold at takeout during the state of emergency. We do, however, object to making this law permanent. Allowing restaurants to deliver beverages and wine after the state of emergency ends gives restaurants an ongoing advantage to convenience stores, which depend on beer and wine sales for a significant percentage of their revenue. Committee should not pick winners and losers. Despite remaining open as essential, we are all struggling to remain viable. We're trying to claw our way back toward profitability. It's an uncomfortable time for all, but it will be temporary, unlike this proposed amendment. Most importantly, this amendment lacks necessity. There are well over 1,500 retail outlets owned by private businesses and the state where beverages and wine are readily available to customers throughout New Hampshire. We see no need to expand the current listing categories where the products are sold for off-premise consumption. There's absolutely no need for it. Putting the shoe on the other foot, it's akin to creating a new license category, allowing all off-premise beverage and wine retailers to permit on-site consumption at the retail stores. We ask instead that all businesses respect the current license categories. And if they want to sell retail, then they should do it. If they want to have on-premise consumption. Yep.
Mr. Moran, I just wanted to let you know that you've approached the 3-minute mark.
Okay, I'll finish up in 2 seconds. Basically, we request that everybody respect the current license categories and that these decisions are best made on a case-by-case basis by each business owner. And secondly, as it relates to this license category, we believe the volumes that are presented, roughly 20 servings of alcohol, are not consistent with the on-premise consumption license. And we believe this amendment, in summary, lacks necessity. It creates an unfair market disadvantage at a time when we cannot afford to pick winners and losers, and is inconsistent with the intent of the current on-premise license category. Thank you for your consideration. We hope the committee votes that this amendment ought not to pass. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
Madam Chair, Representative Packard is back.
Okay. Good afternoon, Representative.
Thank you, Madam Chair. I'm calling, speaking on part of the last amendment that just came on, the fact that of the, I think it's House Bill 274. And that has to do with the fact that we're trying to, this is something that we've been working on for 3 years, trying to bring everybody into compliance with the rooms and meals tax. This is a new type of way to rent cars. A company called Turo and other people are renting cars in this nature, and they haven't been paying the rooms and meals tax as we require car rental companies to do. The Ways and Means Committee this year, it was delayed last session because of the Wayfarer lawsuit, and that was settled. And now we're trying to put it through again. It came out of the House Ways and Means Committee unanimously, and pretty much passed the floor unanimously. All this does is add these internet car companies that are renting cars. It's a different platform, but they're still renting cars, to require them to pay the rooms and meals tax. And when it was in Ways and Means, some language was added to include the Airbnb type businesses also, the short-term rentals. And all this amendment was worked out by DRA so that they could do their job. So I hope that you'll support this particular amendment, and we can finally get this thing done and put a clear, fair playing field out there for the car rental companies.
Thank you very much, Representative. Are there any questions from the committee? Okay. Seeing none, thank you very much.
The next speaker.
Thank you. Thank you.
The next speaker is the legal coordinator for Fish and Game. I don't have a name.
Thank you, Madam Chair. This is Paul Sanderson from Fish and Game, and I'm here to speak in favor of several different sections of the amendment. First of all, Section 91, which was House Bill 496, which makes a technical correction that was caused when Senate Bill 187 and laws 2019 were passed. It will allow us to register antique snowmobiles from non-residents of the state. Secondly, sections 112 to 116 of the amendment, which we have drafted following a meeting at at GELCAR on May 29th, having to do with the OHRV registration rules. Legal staff of the Administrative Rules Department raised two questions of authority. First, whether we had the authority to collect an internet transaction fee. We have sought corrective legislation in section 112 of the bill, which would allow us to collect that fee. And then secondly, we do register machines primarily to individuals. However, there are businesses that have legitimate needs to register OHRVs, primarily in the utility field and in the ski area field. We have done that for many years, but the question was raised as to whether we had the authority to register to business entities. So sections 115 and 116 would correct that omission. These were brought at the request of GELCAR, and it is our hope that with your favorable vote on this, we'll be able to report to them on June 19th that we have brought the matter forward for correction in the legislature. I'd be happy to answer any questions for you.
Okay, thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Stacy Ober.
Good afternoon, Ms. Ober.
Stacy, can you hear me? Now we can.
Oh, very good. Thank you. Good afternoon, Chairwoman, members of the committee and staff. I appreciate the time to speak with you. My name is Stacy Ober. I am the legislative analyst in New England for the American Kennel Club. And I'm sharing with you some concerns relative to Amendment Section 31, starting on page 8. And I have confirmed that the substitute amendment 1407S has identical language to the concerns that I raised for you this afternoon. I appreciate that Senator Rosenwald has acknowledged there's a number of House and Senate bills that have been rolled into this amendment and that they overwhelmingly have had Senate hearings. I just want to respectfully note that House 1627, establishing the animal record database, is on the House consent calendar for a vote. It has not yet been sent to the Senate. However, the bill itself would basically establish phase 2 of changes that were made last session with regard to submitting health certificates upon the transfer of an animal to the Department of Agriculture, which we're grateful to see was reinstated. It had been removed a couple of years ago, and we support the health certificate database transfer component of the amendment. The concern is that when the health certificate language was reinserted last session in the budget by the Senate, the total number of dogs that may be transferred without being licensed as a pet vendor was decreased down to 25. And in RSA 437.1, that change has made it this past year nearly impossible for hobby breeders, which are affiliate club members of the American Kennel Club, to comply with obtaining the state-issued pet vendor license. Specifically, hobby breeders, their sole purpose is to breed their personally owned dogs for their own enjoyment in sport, hunting, conformation, and exhibition. Some breeders are personally breeding their own dogs to serve as service animals. And under RSA 437.1, the pet vendor license application requires an individual to submit proof that the zoning enforcement official of the municipality wherein any facility is to be maintained has certified that the facility conforms to the municipal zoning regulations.
Excuse me, Mrs. Ober, I just want to let you know that you've approached the 3-minute mark.
So the solution that I wanted to acknowledge is that we have breeders who have for 15 years been breeding animals and have asked for a special certificate of conformity from their town and have had to retain legal counsel because the town has refused to issue the certificate so that they can successfully secure a pet vendor license. Two bills that have been filed and voted and approved by the House and sent to the Senate include House Bill 1630 and House Bill 371 that would fix the pet vendor definition, ensuring that individual breeders could in fact comply with the pet vendor license requirements by grandfathering them in on the number of dogs that they would be allowed to transfer by working with the Commissioner of the Department of Agriculture. So I have submitted written testimony. I know Chair Almay today responded to my email to you all, noting that House Bill 1627 is on the House consent calendar in these unusual times. If you're rolling up bills, I strongly encourage you to avoid our opposition of the amendment by incorporating the language from House Bill 1630. Thank you for your time.
Okay, thank you very much. Are there any questions from the committee? Okay, seeing none, thank you very much.
Ken Mahler.
Good afternoon.
Thank you, Madam Chair. My name is Ken Mahler. I own the Mahler's Real Estate in Hancock. However, today I'm representing the New Hampshire Association of Realtors as the Vice Chair of the Public Policy Committee. Realtors are strongly opposed to language which appears on page 51, starting on line 35 in Amendment 1407. Our opposition is solely with Section 78 of this amendment dealing with zoning and planning, cease and desist orders. This language creates a new authority for municipalities to place liens on real estate without having a court order. This is really unprecedented territory, denying due process for property owners by eliminating the need for a town to seek judicial approval before placing a lien on a property. We also think that denial of due process before government places a lien on property raises serious constitutional questions. Keep in mind, this language provides no procedure by which a town must follow when placing this lien. Currently, RSA 67617-A allows the town building inspector, code enforcement officer, zoning administrator, or any other official designated as an enforcement authority to send a cease and desist. This language allows some individual to also place a lien on the property. There are numerous situations where town officials have provided cease and desist orders, which property owners believe are in error. The court makes those determinations who is right. This language gives towns judicial authority and places the burden on the property owner to provide their innocence as opposed to the town having to show guilt. I would also point out that RSA 511 and 511-A already provide a detailed prejudgment attachment procedure which include a judicial review. If that statute is not working for municipalities, then we should be looking at ways to address their concerns through that existing statute. We recognize the language originally was in SB 460. However, it was our intention to bring these matters to the House during its hearing on the bill. Obviously, that's not going to be possible. We would ask for this section to be removed from the bill, and we would certainly be willing to work with the sponsor on the legislation if she would like to reintroduce it in 2021. Thank you very much, Madam Chair.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you again.
Kate Fry.
Good afternoon, Kate.
Kate? Hold on. Kate?
Got it. Can you hear me now?
Can.
Okay, thank you all. I also just want to thank all the staff that are working so hard to put these on. I don't know how you're doing it, but thank you all very much. I am providing testimony specifically to pages 19 through 20, formerly SB 512, which allows on-premise licenses to relative to the transportation of beverages and wine, again, formerly SB 512, and that's sections 53 and 54. New Futures opposed this bill when it was being heard in the Senate. It would allow restaurant delivery licenses to deliver beverages with food ordered from on-premise licensees. We're very concerned about this opening the door to the growth of industry with several app-based services. While we know this bill doesn't particularly do that, we would find that this would be a huge policy shift with New Hampshire's regulatory system. And policies such as this one is in place so we can regulate where and how alcohol is purchased. Back to the previous speaker who spoke also on this bill, I agree that this is currently an executive order to deal with the issues that the restaurants have had because of the emergency order to not have dining for several months. And we understand that this has been a huge economic issue, but they were granted the ability to do this through an executive order that will be in place until the state of emergency, as long as that's in place. So we feel like this is duplicative. It's somewhat irrelevant because there's already an executive order in place. We think because this is such a huge shift in the alcohol policy arena, and a lot of others are going through this too, before this becomes law, we should really reevaluate whether we should make this change permanent. We need to know how many businesses are taking advantage of it, if it is really helping them with their bottom line. I'm concerned about the lack of training on safe serving in terms of underage drinking. You have delivery drivers who are delivering alcohol to places, and we have no idea what kind of training is going on as far as serving someone who's over intoxicated or proofing them correctly. And I think we also have to reevaluate whether we should have increased fees for expanded enforcement on this issue. So again, it's this testimony is just pertinent to that section of the bill, and New Futures does oppose that section. And thank you for allowing me to provide testimony.
Thank you very much. Are there any questions from the committee? Okay, seeing none, thank you.
Marissa Chase, if you could put your hand up, I'll call on you next. But in the meantime, let's go with Robert Wells.
Good afternoon, Mr. Wells.
Mr. Wells,
Yes,
go ahead.
I'm here to testify on behalf. First of all, my name is Robert Wells, Hopkinton, New Hampshire. I'm a senior attorney at Plain Middleton.
Ms. Martone, I can just barely hear him.
Mr. Wells,
Yes,
you're on the phone, correct?
no, I'm on the Zoom.
Can you speak up a little bit? Because the committee members cannot hear you.
Yeah, I will try. Is this better?
It's a little better.
I don't know why it isn't working, but it's what I have in front of me.
That's better.
That's better. That's good.
Okay, good. I'm here to speak with respect to three different matters relating to the probate court, with respect to the Uniform Disclaimer Act and corrections to the Durable Power of Attorney Act. Most importantly is the one which relates to RSA 553-32, waiver of administration, where I have been working, as well as a group of us who have been working with Judge King, to expand the waiver of administration to more situations which relate to what I call simplified probate requirements. By this expansion, we will reduce the amount of workload on the probate court system, which is now laboring under staff issues as well as time constraints. Basically, this amendment will allow a judge of probate, using its equity powers, to determine when a waiver of probate is appropriate or not. And in their determination, they will be able to move matters forward much more quickly. It also provides that if a person dies, leaving assets to a number of different people, and those individuals choose a person to serve as their fiduciary, that qualifies for waiver of administration. Waiver administration is something that came into law about 2007 when we wanted to remove the oversight of the probate court on probate matters that did not require that. The second issue relates to the Uniform Disclaimer Act. I want to be sure there was an amendment to that, which I hope was sent to you. We had conversations yesterday with legislative offices with respect to that because the Health and Human Services has added a provision. Can you tell me whether you have that amendment or not?
I haven't seen anything, sir.
Okay, well, this was said to, I know to Senator Feltus and to others. So what happens with the Uniform Disclaimer Act, it allows disclaimers to happen outside. You do have it, Senator Rosenwald? The amendment provides for Health and Human Services to continue with respect to filing claims for Medicaid individuals, even when a disclaimer might have been provided. Health and Human Services requested this change to the Uniform Act, and we as a group agreed to it. The third matter relates to the Durable Power of Attorney Act and simple changes that we have made to correct prior problems in the act itself.
Attorney Wells,
Yes,
I just want to let you know that you've approached the 3-minute mark as well.
I'm happy to answer any questions. I know it's the end of a very long day. I've been watching you since 2 o'clock.
Thank you very much for your testimony, Mr. Wells. Are there any questions from the committee? Senator Rosenwald?
Thank you. I see that we have the Uniform Disclaimer of Property Interests Act revision. Is that what you're looking for, Mr. Wells?
Good. I'm sorry, you say you have that in front of you?
Yes, that is part of it. It's section, well, it's on page 43, starts.
It talks about the purpose was added, that's something new. And then in section E, that has been added.
I believe we have it. It came from Senator Feltus.
Yes,
Senator,
that happened yesterday.
Senator Rosenwald, would it be in the new amendment?
Yes, but it was also in 1371.
Okay.
In 1407, I think it starts on page 43. Uniform Disclaimer of Property Interests Act. It repeals and reenacts RSA 563B.
Okay. All right, thank you.
I think that's what Mr. Wells is looking for.
Yes, this is a modernization of the act, as you know, with the trust laws. We're trying to make it more attractive to the state, to bring people in, et cetera. So this is one more aspect of that work that our group, and it's a group of volunteer attorneys in the T&E department around the state, and also working with Bud King. We involve him with every aspect of any legislation that we propose to make sure we either have his blessing or he says he has no comment.
Okay, thank you. Are there any further questions? Okay, seeing none. Thank you very much for your testimony, Mr. Wells.
Thank you.
Marissa Chase?
Hi, everyone. Thank you. For the record, my name is Marissa Chase. I represent the New Hampshire Association for Justice. Adam Schmidt told me that I stammered too much in my first testimony, so I hope I do better this time. This is the bill that I hope to testify on. Included in this amendment is the original text of Senate Bill 444, which the association is in support of. It brings New Hampshire in line with federal tax changes to alimony. And this is actually an instance where it could save clients' attorney's fees by not having to redo prior agreements. So thank you very much for including it, and thank you for all you're doing.
Thank you very much, Ms. Chase.
Okay, Former Representative Finney, please.
Okay.
Can you hear me?
Yeah.
Yes, we can.
Oh, great. I'm going to yell into this computer so I can do it. Thank you, Senator Carson. For the record, I'm Jay Finney, and I am a former representative and been on the Environment and Agriculture Committee for 10 years, ending up as its chair. What I'd like to speak to today about is I don't really object to the animal records database. As a matter of fact, I think it's an excellent idea. I do object to and would like to see remove the provisions for rabies. And it's very simple. Right now, the state of New Hampshire has allowed the town clerks and the towns and municipalities to essentially keep track of dogs, cats, and ferrets by sending rabies certificates to those entities or those municipalities. If that changes, we run into a whole host of problems. And I'll be very brief by saying that those host of problems get into potential of loss of personal identification, privacy, as well as several other issues, particularly for those people who may own just a ferret or cat or a dog, particularly if that goes into a statewide database. I'm going to ask you to turn to page 8, please, section 31, and that deals with the animal records database. And I'm going to make 3 recommendations, and I'll submit this in written testimony tonight or tomorrow morning. If you go to line number 17, you'll see that it says the department shall maintain, and then it talks certificates for any dog, cat, or ferret for which it is required. I would delete records of all and then pick it back up again, records of quarantine. And what you really want to do is you want to encourage the department to essentially look at transfers. You want to encourage the department to look at any animals brought into the state and any other sort of health issues other than rabies. The second thing, and I think this is very problematic, is if you go to page 9, specifically lines 19 through 24, section 5, I would delete this completely, because what this does is this only allows those entities that are listed to be able to have access to records, whereas existing statute, and that's under RSA 466 1-D, allows, and I'll quote this, without otherwise compromising the confidentiality of the files, nothing in this section shall prohibit a body or agency from releasing information relative to health, safety, or safety from investigative files on a limited basis to those persons whose health or safety may be affected, or to a person or agency attempting to provide for the welfare of an animal. And then the last thing that I think is very important is I would then delete also on following page 12, sections 34 and 35. This takes rabies out of the control, not the control, but takes rabies out of the database and returns it or keeps it.
Excuse me, former
Yes?
Representative Finzi, I just wanted to let you know that you're approaching the 3-minute mark.
I understand, but this is a very difficult problem, and I'll sum it up very quickly. This essentially would maintain the rabies where it belongs in a situation of local control. So I would offer that if you do this, in no way will you will these recommended changes interfere with any other aspects of the language of the current amendment or compromise the other aspects of the bill which require better compliance for importing dogs, cats, or ferrets, or transfer of such animals, and which should be the responsibility of the department and its first priority, whereas records for rabies and local control should be the first priority of the municipalities. So with that, I say thank you, and I thank you very much for your patience. And Madam Chair, I will submit this testimony tomorrow in its full written capacity.
Thank you very much for your testimony this afternoon, Representative. Are there any questions from the committee? Okay, seeing none, thank you again.
Thank you very much, Madam Chair, and thanks the committee.
Stephen Robbins?
Good afternoon, Mr. Robbins.
Mr. Robbins?
Hello, I think I'm on the wrong bill.
This is all new to me. I want to be on the 1, 2, 3, 4 FNA.
You are on the amendment to House Bill 1234 FNA.
Perfect. Okay, good. So I want to voice my opposition to item number 49. This amendment is not something that's been voted on by the people that it affects, and it reverses the process of the highway maintenance in the Woodsville Fire District that's been ongoing by the Woodsville Fire District since the 1800s. The residents of the district enjoy well-maintained streets and have been on a continuous improvement plan to ensure the safety of our people traveling on our streets. And we don't believe that if this changes hands, that we're gonna have the same maintenance that we have today. The affirmative vote on this amendment is much more than maintenance of the streets, though. This vote is about further division of a fragile community. I've lived here most of my 54 years and do not ever remember seeing the community so divided. I ask that you please allow our community to work this out and work towards healing and moving forward. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you again.
The next speaker is Mike Summers.
Good afternoon, Madam Chair, members of the committee. For the record, Mike Summers, President and CEO of the New Hampshire Lodging and Restaurant Association. I'm here testifying in support of the language that essentially was Senate Bill 512, and I believe it starts at the very bottom of page 17 and goes on, through to page 19. You've heard some testimony opposing it. I will say that during this COVID-19 issue, it was not a huge help, but it was a help to a lot of restaurants. And so we would certainly urge you to consider passing this and making it a permanent solution. Again, not a lot of restaurants can really take advantage of that. They may not have employees utilized as delivery drivers. So it does limit the scope of what can be done. But for those businesses that did utilize it, it might have been a small piece of their survival mechanism, but it was a very important piece. So I urge you to pass this piece of legislation. I would also like to share with you that this language, before it came before the Senate back in January, we had worked hard with liquor enforcement to make sure that the language and that the controls in place would be effective. And I think that what we've seen during the emergency order that has proven out to be effective. We haven't heard of any issues, and so it has been quite effective. You know, a couple of the concerns that were offered earlier, one was that that delivery would be taken up by third parties, and we would have no control over the delivery mechanism. And I think that this bill does not allow for that, and I don't suspect that will happen anytime soon. So I hope that will not be a deterrent. And then the other comment was relative to fees. And this bill does include an additional fee for the essentially a license addition that you would need to acquire as a business in order to be able to use this action. So with that, I will wrap it up. I know it's the end of a very long day. I appreciate your time, and I'm happy to answer any questions if you have any.
Thank you very much, Mr. Summers. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Sheridan Brown.
Can you hear me okay?
Yes.
Yes, we can, Mr. Brown.
Excellent.
Good afternoon.
Thank you so much, Senator, and thanks for the chance to weigh in. My name is Sheridan Brown, just for the record. I'm an attorney in Grantham, New Hampshire. I practice municipal and land use law as part of my my legal work, and I wanted to just share the experience of one of my clients who gave me permission to do so. I represent a couple that has operated a small non-commercial kennel for about 15 years in the town, meaning that they don't board any dogs in the general public, and they sell only a small number of dogs to generate income to support their hobby. And you know, things went along fine for them until they fell under the requirement to have a pet vendor license when the number dropped from 50 transfers to 25 last year. And in seeking that license, as Ms. Ober referenced, one of the requirements is to get a certificate of conformity with municipal zoning ordinance. They were denied that certificate by the town. The town's board of selectmen in this case operates as their zoning enforcement authority. And the board issued no findings of fact, placed my clients in the position of having to appeal to the ZBA. The decision was upheld. They didn't get a rehearing. Now we have to go to court over this. And the unfortunate impact is that it has undermined the due process and private property rights protections that exist in current statute and outline a very clear process for code enforcement. And the town, rather than follow that process, has shifted the burden onto my clients by just holding up this certificate and really cutting off their established use that they've had for now 15 years without a single notice of violation or any sort of code enforcement action by the town. So, you know, we can go to court over this. We ultimately expect that the court will find in favor of my clients, either because of the fact they have a grandfathered use or because of estoppel equitable doctrines that would prevent a town from taking code enforcement action after so many years of being fine with what they were doing. So I have submitted written testimony referencing Amendment 1371, which would now be 1407. The same provisions are in there for an animal health certificate database. And the concern is with this database, which will now be used to, I assume, help with enforcement by aggregating this data from the health certificates.
Mr. Brown, excuse me, we've been limiting speakers to 3 minutes and you've hit the 3-minute mark. So could you please wrap up?
Okay, I had 2:30 on my stopwatch. So anyway, if you would look over this, I'd ask you to please consider adding the language from House Bill 371, which passed the House and does increase the number of transfers and possibly some of the stuff in 1630, but ultimately to remove that requirement of a certificate, I think would be the best solution. And I'm happy to answer any questions on this.
Thank you very much for your testimony this afternoon, Mr. Brown. Are there any questions from the committee? Okay. Seeing none, thank you very much.
Richard Guy.
Hi, thank you for your time. My name is Richard Guy, and I've had the honor to be elected as a Woodsville Fire District Commissioner for 34 years now. I echo the comments of Haverhill Selectman Robbins regarding Section 49 of this amendment. I respectfully ask as well that you delete that section. It's designed to take over our village highway department here in Woodsville that has been functional very well for over 100 years and is fully funded by the Woodsville taxpayers. This legislation supports the Haverhill Town Manager's belief that if everything in town is fully under her control, the town would be better off. This belief is not held by everyone in town. I would like to say that there's been no local committees formed to study combining the maintenance of our village streets and the town roads under the town's highway department. No plans have been presented as to how this could work. Yet with this legislation, we would be thrust into this situation regardless. This issue has created much angst locally, and our Woodsville citizens have actually asked us to place a warrant article on next week's annual meeting about seceding from the town of Haverhill. The commissioners do not support that concept at this time, but that will give you a little feeling for how that is being received in Woodsville itself. One last comment, there has been much misinformation presented regarding Woodsville's finances, and I'm happy to relate that the firm of Plodzik and Sanderson is in the process of a full audit for our past 5 years. in order to remove any possible doubts related to our handling of funds. It's amazing you folks have been here since 2 o'clock. I don't know how you do it, but I ask that you delete sections 49 of this amendment and allow the local community time to study and decide this issue locally. I'm sorry that you've been burdened by this issue, and I thank you for your time. And by the way, we have no objection to section 50 because we've already accomplished that goal. Any questions?
Thank you very much for your testimony, Mr. Guy. Are there any questions from the committee? Senator Chandler?
Yes, and I almost didn't ask it. Thank you very much, Mr. Guy. I almost didn't ask the question because I assumed you were talking not about that section 49, but actually about what is now section 51 in our most recent amendment. So I just want to clarify the parts if
Okay, well,
So
I think
let's
the
not-
original, it's originally called Senate Bill 414, and it's related to Haverhill and the Woodsville, the town of Haverhill and Woodsville Fire District. Does that clarify that?
yeah, that as long as we know we're talking.
Okay. Thank you
Any
very much.
question? Sure.
Thank you very much.
Are there any further questions? Okay, seeing none, thank you very much.
Madam Chair, I think we're down to our 2 final speakers, I'm thinking, okay?
Okay.
The next speaker would be former Senator Bob Clegg.
Okay, thank you. Good afternoon, Senator.
How's that? Am I unmuted now?
Yep.
Okay. I know what you just heard, but the facts of the matter are that in 2009, legislation was put in that made the highway distribution even more unfair. The town of Haverhill has about 78 miles of road that they take care of for about 750. And Woodsville has 8 miles of road that they take 450,000 from, because of the way the legislature determined that it would stick its nose into local politics and create an unfair situation. I'll also tell you that the town of Haverhill, when it signed the agreements, of the 5 people that signed that agreement, all of them stood to personally benefit because they were all from Woodsville. So they lowered their Woodsville precinct tax by taxing and overtaxing the rest of the people in the town of Haverhill. The town of Haverhill has had a meeting this year. There were a few hundred people there. Everybody, including people from Woodsville, think it's time that the town worked as one, and that the road money has to be used for appropriate purposes. I'll also tell you that while they say there's nothing wrong, the commissioners in Woodsville have no problem laughing about the fact that they use the highway money to operate and repair a private business called the water company. So not only is that unfair to Haverhill, it's also illegal use of highway funds. So what we did with the first half is we forced the commissioners of Haverhill to stop saying, hey, it's the law is the law, and we're not going to sit down and talk about anything and laugh and say, hey, that's the way it is. The people in the rest of Haverhill, and that includes Pike and Senator Haverhill and all the rest, deserve to be treated equally. And the legislature never should have gotten its nose in the whole thing. As far as the financial audits, I will ask you to make sure that's there, because the only reason why Woodsville commissioners have agreed to an audit is because DRA had us put this in there so that they could make them, because for 5 years, the Department of Revenue Administration has been attempting to find out what happens to the tax money and what happens to the enterprises that are run in Woodsville, and nobody's ever been able to get it. In fact, I spent 3 years with someone else working with right to know requests and got absolutely nothing.
Excuse
Nothing.
me, former Senator, I just want to let you know that you've approached the 3-minute mark.
I'm done.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you again.
Okay, Madam Chair, there is one more speaker after this next speaker.
Okay.
The next speaker is Brigitte Codling.
Okay. Good afternoon, Ms. Codling.
Hi, my name is Bridget Codling. I am the town manager for the town of Haverhill, and I have already sent you my written testimony, but I will be adding to it. I'm writing on behalf of the town of Haverhill as the town manager in relation to the amendment to HB 1234 FN-A, specifically the portion that used to be SB 414. SB 414 passed the Senate unanimously on February 25th, 2020. There has been a great deal of testimony before the Transportation Committee, including opposition by the Woodsville Precinct Commissioners. However, there was also tremendous support by the Haverhill Select Board Chair, Haverhill residents, myself as town manager, and others. And it passed that committee and then subsequently passed the Senate. The town has amply discussed SB 414. We have been discussing this in public meetings for months. It started last year prior to the passage by the Senate. It has been discussed since then as well. Particularly, we had an open public discussion on March 8th. At that meeting, there were hundreds of residents that attended. And a lot of the discussion that took place that day, it was a very long meeting, was about SB 414 and the highway departments in the town of Haverhill. Subsequent to that, at the annual town meeting, where over 500 residents attended that particular annual town meeting, that bill was also discussed at that meeting. And unlike, unfortunately, in contrary to what you have already been told, the town of Haverhill was asked to vote on that at that annual town meeting. It was Article 24 of the 2020 warrant, and it passed. So the town has voted on this. They do want this to happen. They are ready for a merger of these two highway departments under the blanket of the town. So overwhelmingly, residents have supported this merger. The town of Haverhill is prepared. We have the skills, the knowledge, and the experience needed to manage and maintain the 8 miles of roads that are within the Woodsville precinct. And I'm going to repeat that. There are 8 miles of roads logged with the state of New Hampshire within the Woodsville precinct, which are currently managed by and maintained by the Woodsville Precinct Highway Department. I myself have 20 years of experience working with the Department of Transportation in the state of Vermont. I have extensive experience with highway design, materials, contracting, and construction management for highways. Our highway department collectively has over 45 years of highway maintenance experience. We are prepared to take on the 8 miles of road within the Woodsville precinct.
Excuse me, Ms. Codling, I just would like to let you know that you've approached the 3-minute mark.
I have just a few more statements. So the town maintains 78 miles of road, and like Bob Clegg already stated, our average budget is about $740. The Woodsville precinct maintains those 8 miles of road, and their budget is on average $450,000. Like I said, the town is prepared to take on Woodsville's roads. We already care for Woodsville's gravel roads, and we're prepared to take over the rest of the 8 miles. So I just wanted to make it clear that the town has very much discussed this. The people of Haverhill have voted in favor of it. And I ask you today to approve the amendment to HB 1234 FN-A regarding the Woodsville Precinct Highway Department.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much for your testimony.
Thank you.
Our last speaker for the afternoon is Senator Gaida.
Okay, Senator Gaida.
Thank you once again, Madam Chair and members of the committee. The day has been long. Your work is tedious, but well done. And I thank you for the privilege of speaking as a state senator from District 2, which includes the town of Haverhill and the precinct of Woodsville. Existing statutes establish in law the interference of 400 representatives, 24 senators, and a governor in the internal financial affairs of the town of Haverhill and the Woodsville Fire District. It's the only statute of its kind in the state and enables the precinct to act with impunity when asked by the town to negotiate because it requires changing state law to do so. They operate under an umbrella of protection that requires no such negotiation, and they have successfully thwarted such negotiations for years. In researching the peculiar financial arrangement between the town and the precinct, I reviewed the last financial review of Woodsville's fire operations. That review, decidedly and distinctly not an audit, was the first one done in over 100 years, raised serious red flags about the condition of the precinct's finances. Working with the DRA, it became quickly evident that serious accounting lapses exist and continue to exist for over 100 years. The precinct is operating in violation of state law, and the precinct commissioners for the last 6 years ignored hundreds of telephonic, email, and written requests to conduct the audits required by law. I could go on, but 2 points need to be made. First, the current statute that we're trying to change violates in every sense the principle of local control by exerting state control over the distribution of locally raised and appropriated highway funds. No other precinct or municipality in the state has such statutory immunity from local control. Second, if any resolution of the internal accounting lapses of the precinct and of the financial arrangement between the precinct and the town is to be achieved, the existing statute must be repealed, and DRA must be given the tools to ensure that the Woodsville Fire Precinct complies with the agreed upon process to get its financial house in order. Those two things are precisely what this amendment accomplishes. Two interesting things have come to light. First, the precinct recently hired a firm to attempt to organize years of records that are in utter disarray. That firm is not Plodgett and Sanderson. Second, the precinct has consolidated the 4 questionable enterprise fund accounts into one amid an investigation by the Department of Revenue Administration and the Office of the Attorney General. Senator Waters, Chair of Transportation, fully supports this bill. The Board of Selectmen of the Town of Haverhill support this bill. The Department of Revenue Administration supports this bill because it gives the commissioner the enforcement capability she doesn't have currently to make sure that the precinct's egregious disregard of state law and financial accounting principles is made right. Mr. Guy's written testimony attempts to paint this legislation as divisive and unnecessary and states, quote, "We have already resolved the audit issue." Yet earlier today, James Gary, Director of the Municipal and Property Division of the Department of Revenue Administration, issued the following statement to me about the finances of the Woodsville Fire Precinct and authorized me to repeat it to you. Quote, "The lack of audits, the commingling of funds, and the lack of any meaningful internal controls makes the Woodsville Precinct one of the most egregious examples of non-conforming financial management the DRA has seen. As further evidence, if one were to travel the back roads in the town of Woodsville, they are in deplorable conditions with potholes and cracks. So the funds that are supposedly being spent on roads apparently aren't being spent on the Woodsville's back roads. With this bill, I ask you to please return local control of local tax revenues and appropriations to the people of Haverhill and the Woodsville Fire Precinct. Take the state out of their business, and please give the DRA the ability to require a precinct that has ignored the law repeatedly to come into compliance with that law. Thank you, Madam Chair.
Thank you very much, Senator. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you, Madam Chair.
Ms. Martone, was Senator Guy the last?
I believe so, Senator.
Mr. Roberge, do you see anything else?
I don't see any other hands or anything like that. I think we're all set.
Okay, I'm going to go ahead and close the public hearing on the amendment to Senate Bill 1234, 1371S, and I believe the other number is 1407S. So, okay, it's closed. So can I get a motion for executive session?
Kavanaugh moves.
Senator Kavanaugh, and I think Senator Rosenwald, you might need to unmute because I saw you go. So moved.
Yes.
Okay.
It's been a long afternoon.
All right, Cindy can have
I've
it.
been at this all, Senator Chandley and I have been at this all day long. Because we had judiciary this morning. Okay, I think that in my personal opinion, I think the First Amendment and the last amendment, I think.
Senator Carson, we need to take a roll call vote in order to go into executive session.
Oh, really? Okay, so, all right, let's call the roll for the executive session. It was moved by Senator Kavanaugh, seconded by Senator Rosenwald. Senator Reagan,
Yes.
Senator Rosenwald,
Yes.
Thanks,
Senator Chandley,
Yes.
Senator Kavanaugh,
Yes.
and Senator Carson, yes. Okay, thank you all for this very long afternoon. And most of all, thank you to Senator Rosenwald for all the work she did on these amendments and putting things together. What a Herculean task this has been for her. And I want her to know that I appreciate it very, very much.
Thank you. Thank you.
I think that maybe the first amendment and the last amendment needs some work just based on the testimony that we've gotten. And I don't think it needs a lot of work. I think there's just a few little things here and there. I do think the second bill that we have this afternoon, 1491, there's just been one request really to change something in here. And that was requested by the electricians board dealing with the quorum. And I have the language here someplace. I know I wrote it in here. I should have marked it. Where they're just asking for their quorum to be amended to say that one member of the quorum must be a public member. And I wrote it in here, and let me see if I can find it. I did talk with Senator Gaida, and he was fine with that because it was his underlying bill. It is on Amendment 1388S. It is on page 73, line 23. And it deals with the organizations and meetings. So it would read, beginning on line 21, a quorum of a majority of the members of the board appointed by the governor and council. And then the new language would read, one whom shall be a public member. And that's the only addition. So that I think I'm going to propose as a committee amendment to this amendment itself. What are your thoughts? Senator Rosenwald?
Thank you, Madam Chair. I'm fine with that.
Second.
But I want to say that I did speak with the Senate president, and she would like us to try and exec all of the bills today because there's very little time later this week. I'm prepared to make motions on the other two as well.
Okay, well, we can talk about them, certainly. I think we can
Thank
talk.
you.
So,
But I'm fine with what you're proposing on adopting 1388 with the electricians change.
okay.
And I would
so-
move that if you're looking for a motion.
Okay, is there a second?
Second.
Okay, seconded by Senator Reagan. So we have to do a roll call on this, Cameron?
We do. Let me just clarify and make sure I have exactly how you want it to read. We're on page 73 of Amendment 1388S.
Yes.
On line 23, at the end where there's currently a period, we'll insert one whom shall be a public member.
You got it.
Okay?
Okay, so let me call the roll. Senator Reagan,
Yes.
Senator Rosenwald,
Yes.
Senator Chandley,
Yes.
Senator Kavanaugh,
Yes.
and Senator Carson. Yes. So, this is kind of strange. So I need a motion to adopt Amendment 1388S with a committee amendment. Is that a correct motion? I'm looking at our staff.
I would move that.
Okay. So
Second.
Senator Rosenwald moves the adoption of Amendment 1388S with a committee amendment addressing the quorum for the electricians. Is there a second?
A second.
Senator Kavanaugh seconds. Okay, is there any other discussion on the proposed motion? Okay, seeing none, all in favor say aye.
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 You have to do a roll call.
Got a roll call. I'm sorry, I'm used to doing it the other way.
Right.
Senator Reagan,
Yes.
Senator Rosenwald,
Yes.
Senator Chandler,
Yes.
Senator Kavanaugh,
Yes.
and Senator Carson, yes. Okay, I have to step away for like 2 minutes because my iPad is almost dead, so I got to get the charger to plug it in. So, hold on a second.
I'm glad the rest of us were prepared.
Right. I've been plugged in.
Okay, now I have to change my seat so I can at least get it. Well, whatever, I'll figure it out. Okay, I think we're charging, okay. Okay, so we have these other amendments. Sorry, I have to do this so it fits in the thing here. Is there a motion on the first amendment?
I'm sorry, Senator
We can
Carson.
begin discussing.
Senator Carson, who's going to take out 13 or who is going to take?
I
out-
will.
Okay.
Okay.
I would make a motion if you would recognize me.
Okay, I just want to make sure because I have everything here. So we have amendment 1392S to House Bill 1245. Is there a motion? Okay, Senator Rosenwald moves on to pass. Is there a second?
Okay.
And Senator Reagan seconds. Okay, I need to call the roll.
I was gonna recommend a committee amendment to it. That's what my motion was gonna be.
Oh, okay, so, okay, I'm trying to.
So can I
because this is a
withdraw that
different-
motion?
Okay, that's fine. So, all
Okay,
right.
so if I could, I
think-
would,
Don't we need to have a motion to adopt the amendment before we can talk about additional amendments?
So the technical procedure is to adopt a motion on the bill to open discussion of the bill. And then
Because
you can,
usually what we do in committee is we have a motion on the amendment and then we have the amendments to the amendment. So this is a little different kind of a process. So that's what I'm a little concerned about.
Alan, are you here to provide any input on this?
Sorry. Sorry, what was the question? I apologize.
Okay, the question was, do we need to have a motion to adopt an amendment before we can adopt amendments to the amendment?
We need a motion to adopt amendment. We need to have discussion on, open the discussion for the amendment. And then I think that proper procedure would be that we would then have the amendment discussion, the amended amendment discussion within that discussion, and then we would pass vote.
Okay, I was right then. So Senator Rosenwald, would you like to?
yes, I would move then amendment 1392S, but I am going to propose that we adopt the languages that were proposed by the Department of Health and Human Services on tobacco, child fatality, recovery housing, and also the offshore wind changes that Senator Waters worked on with the governor's office.
Okay, is there a second?
Yes.
Senator Chandler, are you seconding?
Yes.
Okay, so let's do a roll call. Senator Reagan,
Yes.
Senator Rosenwald,
Yes.
Senator Chandler,
Yes.
Senator Kavanaugh,
Yes.
and myself, Senator Carson, yes. Okay, let's talk about the proposed amendments. The only concern that I have is Senator Kavanaugh has not seen the language from the Department of Health and Human Services. This was his bill on recovery housing, and I don't know, Senator, if it's strong enough for you, because that was your comment.
Yeah, well, John did send it over, and that is the same language I discussed in March. I thought there was newer language that came out. I'm fine with passing this, but in my comments, what I want to do is at least talk to him going forward. I'm fine with this language. It's,
Okay. If you're okay with that, then I don't know how the other committee members feel, because I'm not sure if you've actually seen that language.
I believe that
Senator
was
Rosenwald,
included
have
in
you
one of
seen
the
it? Senator Chandler,
Yes.
Senator Reagan?
We saw it yesterday.
Okay, Senator Reagan, did you see it yesterday?
Yes.
Okay. Okay, so that's one. Do we need to take a separate vote on every single one? Every single proposed amendment, or do we do it all at once?
We heard them all at once.
Okay. All right, the other is the language from Senator Waters concerning the off-wind task force. Has everyone had an opportunity to look at that?
I can say also that his amendment shortens the bill
Yes, it
by
does.
several sections
Yeah.
and
it
takes
does.
out the appropriation.
Okay. Okay, I just want to go back and check my notes, because I was taking notes as we were going through this. Let's see, the child fatality committee language, I believe Senator Rosenwald, is that all in the bill, in the amendment?
No, that is what was in your amendment from February that never
Okay.
went to the House, but the department brought it forward to us today. And I was okay with it because you were okay with it. It had your
Yeah,
name on it.
we had worked on that language, so it is, and I've got the amendment number here. It is 0876S.
Mhm.
And so it does address the addition of the issues that were brought up by the Department of Health and Human Services. It was an amendment that was created to bring to the House when the House had the public hearing. So I would like to add amendment 0876S to the proposed changes to the bill, to the amendment number 1392S. Let's see, most of them were, we've got the recovering housing, child fatality,
Tobacco.
hearing, New Hampshire. I think that most people were
yeah, I tried to do it without
were
too.
in support of the amendment. The only thing that seemed to be a little controversial was the Lucky 7 tickets. I'm not sure how folks feel about that.
I'm good. Let them
To
do
go
what they
from
want
50
to do.
cents to $1, Senator Reagan?
I'm good with them. Let them do what they want to do.
I'll second.
Okay. So it seems like everyone's okay with that. Let's see, Ms. Fry was opposed to the specialty beverages. It increased the availability of alcohol. And I think that was it. What do you folks think about that? Are you okay with the specialty beverages?
That's been discussed extensively.
Okay. Senator
also-
Chandler, did you have a comment? I saw Senator Chandler, you had your hand up.
No, not.
Okay.
No, I don't. Nope.
So
I'm
we
good.
have a number of proposed amendments. Mr. Lapine, do you want to read those back to us?
Sure. So I have the adoption of prepared amendment 0876S, which is Senator Carson's name from February. I have the adoption of proposed language that John Williams sent over regarding Senate Bill 633 and recovery housing.
Okay.
And then I have Senator Waters' offshore wind language, which was sent over by Alan at 2:53 p.m.
Okay.
And the
Okay, so
tobacco.
those are, I'm sorry, was there something
There
else?
was the tobacco. Yes, the department had suggested language on the age of tobacco that just inserted, I think, 3 other words.
Okay, let me.
I'm looking for that. Let's see, Paul Minahan.
Yes, Abigail Rogers sent it over at 12:56 p.m. It adds the phrase "or derived from."
Correct.
Yeah.
Also in that email is references to milk products and pasteurization of raw milk. Was the
Yeah,
committee-
that's in the other bill.
Right.
Yeah, we'll talk about that one in the other bill.
Okay, just want to make sure that was still on our radar.
Yep.
Okay. Okay. So we would include the language and derived from
Is it and or is it or derived from?
and or derived from. Okay. Okay, so that is the motion we have in front of us. Is there a
Move
motion
on the
to
ballot?
adopt that language? Senator Rosenwald moves. Is there a second?
Second.
Seconded by Senator Reagan. Is there any further discussion on the proposed amendments to the amendment? Okay, seeing none, I will call the roll. Senator Reagan,
Yes.
Senator Rosenwald,
Yes.
Senator Chandler,
Yes.
Senator Kavanaugh,
Yes.
and Senator Carson? Yes. Okay, I think, let's make sure we finished with that one.
We have to vote OTPA on the bill as amended.
Okay, so we have House Bill 1245. We need a motion of ought to pass as
Move
amended.
ought to pass
Is there
as
a
amended.
motion?
Second.
Okay, okay, Senator Reagan moved it, seconded by Senator Rosenwald. Okay, is there any further discussion on the bill as amended? Okay, seeing none, all in favor say aye. Oh, no, sorry, gotta call the roll. Senator Reagan,
Yes.
Senator Rosenwald,
Yes.
Senator Chandler,
Yes.
Senator Kavanaugh,
Yes.
and Senator Carson, yes. Okay, we've done 2.
And who will take that out, Senator?
Senator Rosenwald, do you want to take this one out?
I would love to.
Okay, so this one's done. So I do not have a copy of 1407. I only have a copy of 1371. So I know that there's some differences between the two. I didn't get a copy of this morning. We were on judiciary, so I prepared this yet last night. So
Oh, I'm sorry.
yeah, that's okay. So I think what we're gonna have to do is just kind of spend a little time. I mean, can we not do this one? I really think that there was a lot of testimony about it, and there was a lot of proposed changes that people had asked for. I don't really feel that comfortable in voting on this. We had just all kinds of requests about things that they were talking that they needed to change, and so I don't know. What do you folks think?
Could Mr. Raff tell us when we might be able to accept this one if we don't do it now?
It would be
Like
very
Thursday
difficult.
night or something.
Yeah, without knowing when election law and municipal affairs was going to get done on Thursday afternoon, that's pretty much our only option, but it would have to be, late at night. It could be as late as 7 o'clock at night or something like that. I mean, I understand obviously there's a lot to go through, and there were some things that, you know, were new to some of you and some of us. But I mean, again, it's up to the committee, but it would be really great if we could get this through so that we can pass it for session when we go
Yeah,
next.
I don't mind if we have to do it at Thursday night at 7 o'clock. I just want everyone to be comfortable with what they have in front of them, and they know it and they understand it. Again, because there was, I think, more conflicting testimony in this one bill than there was in the other two combined. So,
Again, it's up to the committee.
I mean, what do you folks think? You know, to do Thursday night?
I can do
It probably won't take that long because it'll give us time to look at it and plug in all the language, and see what it looks like. And then we can have a discussion and vote on it. Shouldn't take more than a half an hour.
Do you guys want to, are all the committee members, like, how do you guys feel about it?
I can do Thursday night.
I could do Thursday night.
Senator Reagan?
I'd rather not.
Okay, Senator Kavanaugh?
I mean, I'd love to get it done now, that's for sure. I can do Thursday, but
Yeah, I agree too, but I just think that there's some things in there that we just need to really be comfortable with before we vote on it. That's all. So I'm just asking that we wait until Thursday night.
So can I just recap what we're probably going to talk about Thursday night? Is the animal sections, which is 31 through 38, maybe the Woodsville section, the zoning violation section, which is 78, which the realtors didn't like, and Health and Human Services wants us to delete a couple of words about raw milk.
Right.
Which were my notes. Did I
Yes.
miss any?
And those, I think there's a little bit of controversy about the beverages with restaurants being able to sell beverages. I think people might want to be a little more comfortable with that one. Let's see, I didn't think the Woodsville thing was controversial, especially after Ms. Codling talked about how the community supports the bill. So I'm okay with that one.
Okay.
It's from former Representative Finney. I think that he sent us testimony, and I'd like to review it because he talked about removing the provisions for rabies, and I just want to make sure that I really understand what it's doing before anything else. So other than that, I really didn't have a lot of objection. I just want to be comfortable, and I want to see the differences between this amendment and the new one, 1407, because Senator Rosenwald, you said there were some other changes in there.
Yeah, there were two. Well, one of them was just new, the correct language on the Charter Commission. It's just a newer version that had been adopted. One was including facilitators of car rentals and hotel rooms in the rooms and meals tax. That is a bill, I believe, that was sponsored by Representatives Packard, Hinch, Major, and that was not controversial in the House. I don't think we heard any testimony in opposition to it. And yeah.
Fish and game.
Yeah, the fish and game, which was about OHRV and snowmobile registration. So I don't think any of the differences were controversial. Personally, I would be okay with eliminating the animal database sections entirely and having them come back in a separate bill. To me, that's the part that needs the most thought. I mean, that's sections 31 through 38.
Right. I had a question though, and it's on, the 1371. On page 54, it says snowmobiles definition, antique snowmobiles. And it said section 2, antique snowmobile means a snowmobile, which is any of the following, and then there's nothing. I don't know if they just OLS forgot to put something in there, but it doesn't say anything. It goes right into the next section on
thought it was
90
already
on water
defined.
pollution. So I think that there's an issue here.
There already
With
is
this
a
amendment.
definition because we already register them.
Yes,
So I think that part of current statute was not being changed.
yes.
Right.
Okay, it just looks strange.
It looks weird, but sometimes
Okay.
that's how they draft it.
Okey doke. All right, well, why don't we plan to meet on Thursday? Hopefully, we will get
Oh.
a clean amendment
Senator
that
Carson,
has things and we can talk about it.
I'm sorry, Senator Kavanaugh has his hand up.
Yes, Senator.
Thank you, Griffin. I would like to propose something too with that. I think this is the right one, HB 1234 FNA, about eliminating some of the lines for the local zoning that the realtors were asking about. I'd like
Yes.
to, I can work on that and hope and get that done for Thursday as well then.
Okay.
Also,
yeah, I
something to
think they
take
asked for-
consideration, sorry.
I think
I was
they
gonna
asked
say,
for
we're
it to
gonna
be
need-
completely removed. So, okay, we can, we'll work on it and see what we come up with for Thursday.
Just so you guys know, we will have to do an addendum calendar to that. So I just listed, just so you know that we're gonna do this just for this one hearing. Want to make you all aware of it.
Okay. Okay. I don't know, do you folks want to meet tomorrow? Tomorrow night? Would you have to do an amended calendar then?
Yes.
Oh, okay. I just hate being in this position, and knowing that there's some things in there that we really need to take a look at before we vote on it, so.
If we can meet tomorrow night,
Well, it's a problem is getting an
Right.
addendum calendar printed with enough notice for the public for us
Okay.
to have the meeting.
Yeah,
Correct.
okay, yeah, they need 24-hour notice, so. All right, well, why don't we just stick with Thursday? Hopefully, all the questions will get answered and we can take it from there. And it won't take too long. Okay? Okay, can, Griffin.
Great.
So can I get a motion to come out of executive session?
So moved.
Senator Reagan?
Guys, actually, hold on one sec. Sorry to stop one more time. I would also, it's possible, I know that we're not trying to extend any other amendments or anything like that, but if we wanted to, as long as everybody's sure you're fine, you can make it, please let me know your availability Thursday night. But we got to talk to the clerk's office and we got to get a calendar out. So we'll be
Okay.
in touch immediately after this.
Okay, terrific. Okay, so Senator Reagan has moved that we come out of executive session. Is there a second?
Second.
Seconded by Senator Chandler. Let's call the roll. Senator Reagan,
Yes.
Senator Rosenwald,
Yes.
Senator Chandler,
Yes.
Senator Kavanaugh,
Yes.
and Senator Carson, yes. Thank you all for all your hard work this afternoon.
Thank you.
We had an incredible number of bills. I know that everyone put a lot of work into reading these and making sure they understood what was happening with them. So thank you all very much. And I look forward to seeing you all on Thursday night.
Quickly.
Take care. Bye-bye.
Bye, everyone.
Bye.
Bye.